and welcome to the quarterly board meeting of the Osteopathic Medical Board of California. I want to ask everyone who is in the room and sitting on this dais to please put your cell phones on silent. This meeting is being held on Tuesday, August 25th, 2026, and the time is 10:01. This meeting is occurring at the Department of Consumer Affairs, 2005 Evergreen Street Hearing Room in Sacramento, California, 95815. Today's meeting will be run according to the Open Meeting Act as required by law. The meeting will be conducted using the following guidelines. The board welcomes public comment on any items on the agenda. And it is the board's intent to ask for public comments prior to the board taking action on any agenda item. During each agenda item, the host moderating this WebEx event will activate the Q&A feature of WebEx and will ask anyone wishing to make a public comment to indicate so by replying yes. The host will then call on individuals who indicate they wish to make public comments by name that they joined the WebEx event as. When called upon, the host will unmute the microphone of the individual and he or she will have 3 minutes to make his or her public comment. The host will audibly announce when the 15 seconds remain to conclude the public comment. After 3 minutes have lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. We have Mr. John Cummings and Ms. Naeem, who are joining us remote. And we need to confirm with each of you if there is anyone in the room with you over the age of 18. Can you say yes or
This
no?
is John Cummins, and no, there is nobody in the room with me over the age of 18.
Good morning, President Pines and board. I too can confirm that I have no one else in the room with me, whether being age 18 over or under. Thank you.
Okay, great. We ask that both of you remain on camera in the entire meeting, and if you have to step away during the meeting, please recuse yourself by letting us know and when you return. All participants will mute their microphone or phone during each presentation of the agenda topic. At the conclusion of the discussion from the board members, I will ask for public comment. At the conclusion of the discussion period, I will call for a vote if necessary or move to the next agenda item. All in attendance should keep their comments specific to the agenda item being discussed. An opportunity for public comments for items not on the agenda will be provided. Please be advised that during this comment period, the board cannot engage in discussions or take action on any matter that is raised, except to decide whether to place the matter on the agenda for a future meeting. We will now establish a quorum. I would like to call the meeting to order. And board members, please unmute your microphones. And Machiko, can you please call the roll?
Will do, Madam Board President. Good morning. Gora Damian.
Present.
John Cummins.
Present.
Brett Lockman.
Present.
Nagin Margabi.
Present.
Amesh Patel.
Present.
Denise Pines.
Present.
Faisal Kazi. Matthew Swain.
Present.
Shannon Walsh.
Present.
You have a quorum.
Great. Moving to agenda item 2, to remind us why we are all present today, our Executive Director, Erica Calderon, will read the board's mission statement.
Good morning, President Pines and members of the board. The mission of the Osteopathic Medical Board of California is the following: to protect the public by requiring competency, accountability, and integrity in the safe practice of medicine by osteopathic physicians and surgeons.
Great. I want to recognize that Dr. Quasi has just joined us. Moving to agenda item number 3, public comment on items not on the agenda. During the meeting today, public comment is welcome on any agenda item as the item is being taken up by the board. Please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between the board members and the public. The only action board members can take is to listen to the comments and decide whether they want a future agenda item on the topic. No other action can be taken on this item at this meeting. Though this may seem at times that the board members are not being responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed to avoid compromising the speaker's goals or the board's mission. In order to allow board sufficient time to conduct its scheduled business, the board will limit the time given to each person to 3 minutes. It is not necessary to repeat statements or views of a previous speaker. It is sufficient just to simply say that you agree. As a reminder, please do not disclose any details of an active enforcement case or a licensing matter. Such discussions are considered ex parte communications as they could provide information to the members that is outside of the record in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where the decision is still pending. In addition, the board would like the public to address the board as a whole and not individual members. The board appreciates your cooperation and assistance in meeting its legal mandate. If you want to comment on an agenda item, please wait until we get to that agenda item. Comments at this time are only for items not on the agenda. And again, please limit your comments to 3 minutes. So at this time, are there any public comments from members of the public that are in the room? Moderator, are there any public comments from anyone online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment for items not on the agenda, please click the raise hand function. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
This might be a fast meeting. Moving to agenda item number 4, review and possible approval of the April 23rd, 2026 board meeting minutes led by Beth Clark, Analyst 2. Thank you, Beth. Good morning.
Good morning. Morning, Madam Board President and board members. So I'm here to present those board meeting minutes from the April 23rd, 2026 board meeting. We're going to go page by page, and if you have any edits or comments, I will make note of those today, okay?
Okay.
I'm going to go ahead and start with page 1. Any edits? Okay, better? Okay, page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page 12.
I did note that on page 11 and 12, with respect to AB 2575, this is John Cummins.
Mhm.
The last line says motion carried to oppose SB 1002. And I think it should be motion carried to support AB 2575.
Got it. Thank you. How about page 13? Page 14. There's no more edits, and I'll turn it back over to Madam Board President.
Thank you, Beth. Can I get a motion to, in a second, to adopt the April 23rd to 2026 board member meetings um, with the addendum by Mr. Cummings?
I move to adopt. This is Dr. Swain.
Can I get a second?
Kamesh Patel, second.
Are there any comments from the board? Any comments from members of the public? Can come on down, Holly.
Good morning. Holly McChris, Executive Director at Osteopathic Physicians and Surgeons of California. On page 10, for the ACCME presentation, I would ask that the comments that OPSC and the AOA had be added to the minutes, please.
Moderator, are there any comments online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment for this agenda item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Great. Machiko, can you take the roll, please?
This is the Youth Land Board
Yes.
Council. The maker of the motion, before we take the vote, would they like to amend the motion to take into consideration the public comment?
This is Matthew Swain. I moved to adopt with the impact of the public comment.
Do we have a second on that as well?
Brett Lockman, I'll second.
Okay. All right. Okay. So we are going to adopt amendments with the public comment recommendation as well as Mr. Cummings' amended addition. So now we're going to do a roll call.
Board Damian,
Aye.
Dr. Walsh,
Aye.
John Cummins,
Aye.
Dr. Lockman,
Aye.
Nagin Margabi, Dr.
Aye.
Patel,
Aye.
Madam Board President Pines,
Aye.
Dr. Swain,
Aye.
Dr. Kazi.
Aye.
Motion carries.
Great. Moving to agenda item number 5, President's Report. So this past quarter, the Osteopathic Medical Board of California has continued to advance our mission of protecting California consumers while strengthening the standards of the osteopathic medical care throughout our state. I want to begin by recognizing the outstanding partnership between the board and our executive director, Erica Calderon. Through our regular meetings and ongoing collaboration, we have continued to set strategic priorities, shape board agendas, and move important initiatives forward. Her leadership has helped keep the board focused on both our immediate responsibilities and our long-term goals. One of our major priorities this year is preparing for our upcoming sunset review. Staff has been conducting a comprehensive review of the board's performance, programs, and outcomes as we prepare for our submission to the legislator. As part of that process, we have been analyzing several years of operational data, and the trends tell an important story about the evolution of this board. Over the past 4 years, the number of complaints received by the board has nearly doubled. While some of this increase reflects disciplinary actions and arrest reports from other states, it also demonstrates a more proactive approach by both our enforcement program. And today, the board is opening cases based not only on consumer complaints, but also when concerns arise through media reports, our fictitious name permit audit program, and our newly implemented CME audit process. These efforts reflect a significant shift toward proactive consumer protection and demonstrate the dedication and initiative of our enforcement team. As we move through the sunset review process, we also look forward to engaging consumers and stakeholders to identify meaningful initiatives that will continue to strengthen public protection. I would also like to welcome Rohit Chopra, who now serves as the inaugural Secretary of the California Business and Consumer Services Agency. Many of you know Secretary Chopra from his national leadership, having served as the Director of the Consumer Financial Protection Bureau from 2021 through 2025. During his tenure, the CFPB recovered nearly $10 billion in refunds and penalties from companies that violated consumer protection laws. His extensive experience protecting consumers and overseeing complex regulatory systems will be a tremendous asset as he now leads the Business and Consumer Services Agency, which oversees dozens of boards, bureaus, and commissions, including ours. We look forward to working with him in advancing our shared commitment to consumer protection. Now, I'd like to take a few minutes to discuss what undoubtedly is becoming one of the most significant issues facing healthcare regulation: artificial intelligence, known as AI. AI is no longer something on the horizon. It has already transformed the practice of medicine and is advancing faster than regulators can fully assess its impacts. As medical boards, we have a responsibility to ensure innovation improves patient care while maintaining public safety and accountability. I am honored to be appointed to the Federation of State Medical Boards Work Group on Regulation of Artificial Intelligence in the Practice of Medicine. This national work group has been charged with developing recommendation and model guidance for state medical boards on the appropriate regulation of AI technologies used in clinical practice. The work group brings together representatives from state medical boards, healthcare leaders, technology experts, and other key stakeholders. We've already held our first meeting and will convene in person in Washington, D.C. on October 2nd to continue this important work. I recently participated in a joint meeting with the National Board of Medical Examiners to examine the impact of AI on the USMLE examination. In exam, many doctors of osteopathic medicine also choose to complete in addition to COMLEX. Here at the board, we are beginning our own AI journey. Both the Osteopathic Medical Board and the Medical Board of California have been approved to use Microsoft Copilot. Ms. Calderon will provide additional details in her report regarding the implementation plans and potential use cases. Because of this work, our boards are also being considered to present our AI implementation experience as a case study at the Federation of State Medical Boards annual meeting in April 2027, a recognition that reflects California's leadership in thoughtfully integrating AI into regulatory practice. There is no question that AI will reshape healthcare regulation in the years ahead, and our responsibility is to ensure that we embrace innovation while continuing to uphold our fundamental mission of protecting the public. And lastly, I'm pleased to welcome Dr. Shannon Walsh as our newest board member appointed by the governor on August 14th. Dr. Walsh has served as a physician in internal medicine, obesity medicine, and pediatrics at UC San Diego since 2024, previously holding medical and leadership roles at several San Diego health clinics. She is active in numerous professional organizations and holds a doctorate of Osteopathic Medical Board from Western University of Health Sciences and a BS in microbiology from UC Davis. At this time, Dr. Walsh, I would like to administer your oath of office. If you will kindly join me in the front of the dais. I don't have to come up here. Where? I will bear truth, faith, and allegiance
that I will bear truth, faith, and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservations or purpose of evasion,
without any mental reservations or purpose of evasion,
and that I will faithfully
and that I will faithfully
discharge the duties upon which I am to enter.
discharge the duties upon which I am to enter.
Welcome.
Thank you.
Thank That concludes my president's report. Do we have any comments from board members? No comments on AI? Okay. Are there any comments from members of the public in the room? Moderator, are there any comments from the public online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this agenda item 5, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, we're going to move to agenda item 6, board member communication with interested parties. So I'm going to start with myself. This past Saturday, I host an event called Wise Boss Wellness. It's an event for women who are in the varying stages of menopause, and we do the menopause recognition awards in the U.S., and we honored Assemblymember Rebecca Bauer Kahn at the event for the work that she's done in the state of California. Is there any other board members that need to disclose any information? Okay. Are there any members in the room that have any comments? Are there any members online that like to make a comment?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this agenda item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, we are moving quite rapidly. We're moving to agenda item number 7, Intergovernmental Relations Report and Administrative Services Update. We will start with an update from DCA with Lucia Saldivar, Deputy Director for DCA's Board and Bureau Relations. Lucia.
All right. Good morning, Madam President, board members, and staff. My name is Lucia Saldivar, and I'm the Deputy Director of Board and Bureau Relations at the California Department of Consumer Affairs. Thank you so much for the opportunity to provide a brief update from the department. Firstly, I want to join in welcoming Dr. Walsh to the board. Congratulations on your recent appointment, and DCA is looking forward to working with you. Please do not hesitate to reach out to our Board and Bureau Relations team. If you ever need any support, we're here to help you. Next, DCA, along with other state departments, transitioned back to office 4 days a week on July 1st, which was consistent with the governor's executive order. DCA wants to recognize board leadership's efforts and partnership as we've worked together to support staff with this transition. And lastly, I just wanted to remind members about some required trainings. The next board member orientation training, also known as BMONT, will take place on October 21st virtually. BMONT is an all-day training which must be completed by board members within 1 year of appointment and reappointment to the board, flagging this for any new board members. In addition, on May 26th, DCA launched its internal defensive driver training, which is now available on DCA's learning management system, also known as LMS. This training is mandatory for state employees, and it includes board members who operate vehicles on official state business. It's a 2-hour interactive session that covers safe driving practices, rules of the road, required forms for state travel, and accident response procedures. Board members can register for BMONT or defensive driver training using LMS, but if you have any questions on accessing LMS, or if you would like to check to make sure that you're in compliance with any of the mandated training requirements, please contact us at memberrelations@dca.ca.gov. This concludes my report. Thank you so much, and I'm available for any questions you might have.
Thank you. Do board members have any questions? Are there any comments from members of the public in the room? Any comments from the public online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Thank you so much.
Thank you.
Okay, now we are moving to our budget office update, and we're joined by Kayla Van Lent from our budget office at DCA.
Good morning. Can you hear me okay?
Yes.
Perfect. Thank you, Madam President Pines, and good morning.
Good morning.
My name is Kayla Van Lint, and I am a budget analyst with the Department of Consumer Affairs Budget Office. I am joined by the budget manager, Brad Lencioni. I want to thank the board and the executive staff for allowing me a few minutes to present on agenda item 7B, the board's expenditure projections, revenue projections, and fund condition statement. First, I'm going to start with the board's expenditures included in your materials. These projections are based on actual data through fiscal month 11. This report includes 2024 through 2025 actual expenditures in green, as well as 2025 through 2026 budgeted and projected expenditures in blue and orange. As we move to the end of the document, you will see the board has a budget of $5.011 million and is projected to spend about $4.96 million with a reversion of 48,000 or 0.96%. At the bottom of the document is a table that shows the completed AG and HQIU budget augmentations. The next document I will be going over is the board's revenue projections included in your materials. This report includes receipts collected through May, and I will go further into the projections as we transition to the next slide. The next document is the board's fund condition statement included in your materials. As a reminder, we read this document from top to bottom and left to right. The left column is the board's prior year, 2024 through 2025, based on actuals. It shows the board began 2024 through 2025 with a beginning balance of $5.098 million. The board collected $4.119 million in revenues, with $1.096 million from initial license fees, $2.737 million from renewal fees, and $286,000 was collected from the issuance of citations, fines, delinquent fees, and other revenues. The board expended $4.274 million, which includes $217,000 in direct draws to the fund for statewide pro rata and pension payments. The board ended 2024 through 2025 with $4.943 million in reserve balance, or about 11.8 months in reserve. The next column shows the current year based on fiscal month 11 projections. For fiscal year 2025 through 2026, the board projected revenues of $4.062 million, with $1.168 million projected from initial license fees, about $2.659 million from renewal fees, and $235,000 from the issuance of citations, fines, delinquent fees, and other revenues. The board is projected to expend $5.015 million, which includes $241,000 in direct draws to the fund for statewide pro rata. The board is projected to end 2025 through 2026 with $3.990 million in reserve balance, or about 9.7 months in reserve. The Budget Office will continue to monitor the board's revenue and expenditures and report back to the board with monthly expenditure projections as we continue to close fiscal months in the prior year and current fiscal years, or current fiscal months in this current fiscal year. A few things to note of the board's fund condition. The fund condition is a snapshot in time. One of the main factors driving expenditure increases in future years is a result of personal service adjustments. These include general salary increases as well as employee compensation and retirement rate adjustments. The Budget Office includes a conservative ongoing 3% increase to expenditures on the fund condition statement to account for these ongoing incremental adjustments. You will also notice revenue is projected static in the out years. Lastly, I would like to note to the board that any future legislation or unanticipated events could result in the board's need for additional resources, which would create cost pressure on the fund. The Budget Office will continue to monitor the board's fund condition statement and keep the line of communication with the board's executive staff open for any future needs or expectations. Again, thank you for allowing me the opportunity to present at today's meeting, and I will be happy to answer any questions that you may have.
Thank you, Kayla. Are there any comments from members of the board? Are there any comments from members of the public in the room? Any comments from members of the public online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay. I will say that Ms. Calderon and I do talk about the budget quite often, and we are watching it as we progress in the coming years, and our reserves are going to be half of what they are at the moment. So that's going to be part of what we're moving forward with during Sunset Review. Thank you again, Kayla.
Thank you.
Okay, we are now going to move to agenda item 8. We have a presentation on the Interstate Licensure Compact, which is going to be led by Marshall Smith, Executive Director of the Interstate Medical Licensure Compact Commission. We are also joined by the Compact's attorney for any questions that folks may have on the legal side of the Compact. Mr. Smith is a dynamic leader with over 35 years of experience in government and health administration. He has led the Interstate Compact for the last 8 years, transforming it from a startup to a streamlined process for licensing physicians across state lines. Under his leadership, the Compact has expanded from 17 member states in 2017 to 42 in 2025. We are not one of those states. Before joining the Compact, Mr. Smith served as the Professional Standards Manager with the Colorado Department of Health and as the Program Director for the Colorado Medical Board. We look forward to your presentation.
Thank you, Madam Chair.
Mr. Marshall, if we can just clarify, we are actually on agenda item 9. So just for the record, we moved AOA since our presenter is not here yet, for later this afternoon or this after this meeting. And then just thank you for being here. We know that the medical board started a discussion about the compact and their interest in learning more about it. And this is why Denise and I, invited you to be here today with us to speak. Thank you.
Thank you. Again, my name's Marshall Smith, and I'm the Executive Director with the Interstate Medical Licensure Compact Commission. We currently have 44 states. Since the time that this was originally set up, we've had 2 more states join us. The most recent is Alaska. We now have 6 states that are not part of the compact: California, as you mentioned, Oregon. So I have to do the map in my head: South Carolina, Virginia, New York, and Massachusetts. And we currently are working on and have legislative activity in New York and Massachusetts, and we're introducing legislation in Virginia and South Carolina in the upcoming legislative session. So there's a lot of interest in the compact, and thank you very much for having me come and talk to you. One of the things about the Interstate Medical Licensure Compact, and I'll start with my first slide and kind of move through this, and I won't read it to you. I've done enough presentations. I know it's not a good idea to read your presentation and keep your audience engaged. But the compact is actually a very simple concept. We have 44 states. We have 59 member boards. There are a lot of states that have both an MD and a DO board. The compact treats all of our boards, whether they're allopathic, osteopathic, or combined boards, each have their role and their separate place in our system and our database. But the compact itself is an idea that if you want a little bit of a history lesson, the United States and our founding fathers realized that there are matters that the federal government should not become involved in, and that states should have the ability to come to agreements between themselves to solve national or multi-state issues. And that's what the compact is. It is a legal agreement between your state and all of the other states that are a part of the compact. It is available for doctors of osteopathy and doctors of medicine. There are other compacts for nursing, for physical therapists. Each health profession has its own compact. We have ours that is for physicians. One of the founding parts of creating our compact was the idea that physicians form a very fundamental base to the practice of medicine in states. And therefore, we created a methodology by which a physician has an accelerated or an expedited pathway by which they obtain a full and unrestricted license. Licenses obtained using the compact license are the same type of license that your board issues through its traditional process. So it is a full and unrestricted license that is issued through our process. And I will hopefully start to clarify why this process works and why that is a key part to this. Again, it is a legal agreement between states and territories. It is constitutionally permitted. It does not violate the California Constitution to join a compact. And as I believe Mr. Masters has pointed out to me, that California currently is a member of 30-odd compacts. The most common compact that states belong to is the driver's license compact. And that is a compact that allows me, with my Colorado driver's license, to rent a car at your airport and drive that car in California without obtaining a California driver's license. They are agreements, they're legal, and they are permitted in the U.S. Constitution. I included a copy of our organizational chart, and you can see that the compact is run by our commissioners. They are the governing decision makers of our organization. We have an executive committee that meets on a more regular basis. Our full commission meets twice a year. They meet in May to approve and review and approve our budget, and they meet in November to consider any business of the organization, including the election of officers. We have an executive committee that can act on behalf of the commission in all matters except for rulemaking. Only the full commission can make rules that are binding as part of the compact. We have 5 standing committees, and then we have a staff of about 30 people that we currently have at our organization headquarters, which is in Littleton, Colorado. All right, next slide. So where we are today, actually we're in the middle of we're preparing to publish it next week, and so we're just final. So you're getting an advanced preview of our new license volume report. The number is now actually closer to 30% of all the licenses issued in the United States in 2025 were through our process. That includes states that are not part of our process in that total number. Almost 50% of the licenses issued through by our member boards, meaning people that the states that are part of our compact, almost 50% of those licenses were issued through our process. It ranges from about 26% is a state that had the smallest percentage of their new licenses issued in that state, up to a high of about 70% of the licenses being issued by that state. So I say that because I want to impress upon you that we are an established process. It is a safe process. It is an important process that many states and California, should you choose to join the compact, you will have opportunities to figure out ways to address the needs of your physician population, but also, and most importantly, your patient population. There are examples of where, and I'll give you the one that I think is the most telling, and to me, one of the most impressive stories. MD Anderson is a cancer center in Houston, Texas. They're a renowned organization. They testified, and it's on the record in Texas, and they advocated for joining the compact. And the reason they did that is they had an idea that would allow them to reach out to more patients and to change the way that they delivered medicine there. The normal practice and the traditional practice and the process that they did before they joined the compact is that a patient would do 2 to 3 visits before to be evaluated, to determine their treatment options and the course of treatment for them. And then they would come to Texas, Houston, Texas, for all of those. They would also go to Texas to get their treatment. They would go home, and then they would come back for their post-care. What they figured out was they can actually reach out to patients who economically can't afford to travel 7 to 8 times to Houston, Texas from wherever they are, and that there are also patients with limited mobility that they could also reach out to. So what they did was once they joined the compact, they licensed their physicians in all of the states. They've divided them up, so they're not in all 50, but each physician has multiple states. They then can treat patients via telemedicine. The patient goes to their local practitioner's office, their physician's office, or their nurse practitioner office. The MD Anderson physician joins that as a virtual consult. So the patient really only has to make one trip to Houston. And again, I bring that out as I think that's an important way in which an organization and a state found a way to do and provide care to their patients. You will do the same thing in California, should you join the compact. Alaska, and I'll use this as my final one, and then I'll move on to the next slide. But Alaska, their First Peoples organization encouraged Alaska to join because they have an issue with getting medicine and getting prescriptions. They have to go to the larger cities, and there are issues with the travel. There are issues with their patients not being able to return home because of other social issues that are involved with that. So what they've done, and one of the things that they contacted us about, is creating health centers on their lands where people that are seeking care don't have to go to the big city to get their prescriptions and to do their examinations. They can actually be done in their community center. They will be done remotely. They're intending to contact physicians to be able to do that. Their physician base is now going to expand because they are part of the compact, and I'll talk a little bit about that. But it was their way of using the compact and our process to be able to help their patients. And again, as I've said a couple of times, California will do the same thing. You have issues, you have concerns that you're addressing actively as a board. We're another tool that will help you do that. Let's see. I think it's also important to note that there are over 220,000 licenses that have been issued through our process, and there are over 65,000 physicians that are using our process currently, and that we have 130,000 letters of qualification, and those are important, and I'll talk about why that's important, that are part of the compact. If you go to the next slide, one of the things about the compact is by joining the compact, your state agrees that the requirements for issuing a license are altered for the compact process. So a physician who meets our criteria does not follow the traditional process to get a license. They follow our process. It's very much, the example I use is TSA pre. We all go to the airport. When you get to the airport, there are two ways to get to the x-ray machine. Everyone has to go through the x-ray machine. Everyone to practice medicine in California needs a license from the medical board or your board. But by joining the compact, you create two ways in which that can be done: the traditional method or an expedited method, which we have established. The other part to that is the compact has the authority to create rules. The rules can only be put into place by the entire commission has to vote on that. It's a majority vote or a majority opinion, the majority rules with regards to passing a rule. We currently have 10 rules that are in place. They're available online. You can see all of them. But we are very conscious of the fact that we are creating rules, and these rules do have impacts on our member boards as it relates to the compact. It's very, very important to note, and it's a common misconception. The compact does not impact your board's ability to regulate the license that you've issued, even if it's through the compact process, to issue discipline, to do investigations, or any of the matters that you have related to your traditional issuance of a license. So the compact rules, the compact statute relate to the compact and your state's implementation of that process. It does not in any way, shape, or form take away from your board's ability to regulate the practice of medicine in the state of California. Now to the meat of the subject. The next slide is, these are the compact steps. And again, these were established in 2017 by our member boards. The first step is that the physician has to hold a full and unrestricted license in a member state. So these are physicians that have a relationship with a state already. They're already practicing. And I'll give you the subtle preview of why our process works. That state has already collected all of the primary source static information. They already have an FCVS report. They've got where they went to medical school, their test scores. They have all of that static data already. By having the physician complete an application, an online application, and having a member board verify that that information is true and correct, other member boards then issue a license based on that verification that's been done by the other state. So, so they have to hold a full and unrestricted license, and they have to establish a relationship with that state. So they either have to live there, which 95% of the physicians that use the compact process live in the state where they are, where their state of principal license is. The other 25% of their practice occurs in the state of principal license. The employer is located in the state of principal license. And then the final one is their state of residence for for federal tax income purposes is the state of principal license. It's the military option. There are California licensed physicians who are using the compact currently. The reason they are able to do that is they also have a practice in Nevada or Arizona. 25% of their practice takes place there, or their employer is located there. So there are physicians in California currently using the compact process. I couldn't give you that number. I'm sorry, I don't have that off the top of my head, and I should if I was a really good presenter. But I don't have that. So if one of those four criteria are met and they hold a full and unrestricted license, they can use the compact process to obtain a license. So here are the 9 agreed to steps. These again become the licensing criteria by which a physician who meets these criteria, every one of our member states is then required to issue a license to that physician. So they have to go to an accredited medical school. They could take no more than 3 attempts at each one of the steps at the USMLE or the COMLEX. They had to have done their graduate medical education in the United States. They have to be board certified, and this is a requirement that is for initial qualification. Once they've met the initial qualification, any subsequent letters of qualification they attempt to obtain, the board certification drops off. They can have no prior convictions or criminal activity. They can have no history of licensure actions on their National Practitioner Data Bank. They have to have a clean DEA history. They can have no active investigations open at their state of principal license because that's where they have the license. And they must agree to do a fingerprint-based criminal background check. A physician who meets these 9 criteria is then, our member boards are then required and obligated to issue a license to that physician using our process. In the states that have joined the compact, especially those states that have been very reluctant to consider joining the compact, one of the challenges that I've often issued to them is, how many physicians has your board denied a license to who has met these criteria? And the answer so far is none. So this is a high bar standard. If these standards are met, the physician is issued a license. So some of the general questions that I have prepared, and one of the things I want to offer to you and Erica or Ms. Calderon and I have spoken about is, if you have questions, you can direct them to her. I will prepare a response, and I'm happy to come back. Who wouldn't want to come to California? So I'm happy to come back at any time to address the board again as you request. So we do an annual study of our, we pull a statistically valid sample of licenses that are completed, and that's where this information comes from. It's also available on our website. So the average number of licenses obtained per physician is 4, with the breakdown 1 to 2, 3 to 7, or 7 or more. We do know there was testimony provided in Massachusetts regarding the licensure process. It costs on average a physician to obtain all 50, the testimony that was provided, for a physician to obtain all 50 licenses in the United States using the traditional method costs about $150,000 to obtain all 50 licenses. Using the compact process, that cost is reduced to about $49,000. We're able to do that because, again, the physician isn't ordering FCVS reports to be sent to all 50 states. They also don't have to then verify licenses held, which can become sort of those things. So it is an effective method. We look at our costs on an annual basis. We know that it costs on average $385 to apply to a single state with traditional methods. So our costs are actually less for a physician to apply. The average processing time, it takes about 38 days to get a letter of qualification. That's the state of principal license verifying all the information from primary source, pulling background checks, pulling the MPD and the DEA information. Almost half, a little over half, get those letters of qualification in 30 days or less. And the average number of days from the LOQ being issued to all requested licenses. So a physician who requests 43 licenses will get all 43 licenses on average in 22 days, with almost half of them issued in 7 days or less. It is a quick, effective process. It's also good governance. As you were talking about the process for your board and you were going through your budget, which I'm a budget person, so I like that. But it allows your staff, who are experts at looking at applications and helping you make decisions about whether a physician should be licensed in California or not. It allows them to focus on those applications that require that expertise. It allows your staff, using our process, to quickly and effectively license those, if you'll allow me to say it, squeaky clean applications. These physicians with their board certified, US trained, have a current license, are already practicing, they've got the experience. So it's a good governance model for boards to use. They are required to comply with whatever continuing education requirements you have. Each state has its own CME requirements. We're developing a system that we are currently rolling out, and we will have all physicians using, which we call our Enhanced Physician Portal. It's a wallet that each physician has that has each state that they've obtained a license from It has the continuing education requirements that the physician has to meet in order to renew their license. And we are working with ACCME and other organizations that provide continuing education credits to have a verification online so that your board staff can then use our system to verify that, and you will have 100% verification that your CE requirements have been met. To the next slide, our costs, the compact charges $700 to the physician to apply for a letter of qualification that's valid for 365 days. They can use that letter of qualification to go back as many times as they want to obtain more licenses. 400 of that comes to the IMLCC for our operational expenses. 300 of that goes to the state or principal license to pay for their costs to be able to issue that letter of qualification. I pulled some numbers very quickly before I came here. States of similar size that use the compact, Florida and Texas, they generally issue about between 10 to 15 letters of qualification per week. And so they're DO boards. There are also states that have both an MD and a DO board. In Florida, their average is 10 LOQs issued by the DO board out of a total of 64. And in Texas, that is 15 letters of qualification for 74 LOQs issued, and that's per week. So you will see that increase. The other aspect are licenses issued. You will see an increase of about 10%. All of our states see an increase of about 10%. California, you will receive more than the average. But in Florida, the DO board in Florida issues 15 licenses per week out of a total of 86 for the whole state. And Texas issues 20 new licenses every week out of a total of 98. And those are averages per week. So you will see that increase. The other part to that is important to you, and it is important to all of our states, is that you will be paid the fee that you charge for having a license issued. You are issuing a full and unrestricted license. It's issued by the DO board in California. There is no such thing as a compact license, so you are paid your licensing fee. We will collect that on your behalf. We will work with your financial people, and we remit those fees to you on a weekly basis. Last year, our fiscal year ended June 30th. We issued over $15 million to all of our member boards in fees that we collected on their behalf. And your renewal fee is paid, so you will be made whole for whatever you charge for a license to be issued by the state of California. If we go to the next slide, kind of the elephant in the room, and one of the things you'll find out about the compact is we are a very open and happy to talk about any issue. Any question is not something that we would shy away from. The Oregon Medical Board published a paper on January 5th, 2023, outlining positions, their board's position why they should not join the compact. And while we disagree completely with their paper, and it is not the compact's position to argue with our boards or to reply to those sorts of things unless we're asked to. And we were asked in 2024 to provide a response to that by the Oregon Hospital Association's chief medical officers. And I believe you've been provided with copies of those documents. Some of the highlights, one of the comments, they said the large states aren't part of the compact, and reality is that Florida did join, and that out of the top 10 states, there was California, New York, and Massachusetts are the only 3 of the top 10 states based on physician population that aren't a part of the compact. So we have 7 of the 10 that are part of our compact. The other comment that they made is that these are bad physicians, or they're physicians hiding. That's not a correct statement. Out of the 65,000 physicians that have used our process, 175 of them have been disciplined, resulting in 346 actions. It's important to note that a physician who is disciplined or loses their eligibility criteria they lose all of their licenses that they've obtained through the compact process. And it's done quickly. Within 48 hours of being notified of a disciplinary action, the compact notifies all of our member boards. You will have additional tools that you can use. If you have a physician that you know is practicing in multiple states and you wish to have the involvement of other states, can voluntarily, that's a key word, you're not required to do it, you can voluntarily share your investigative information. You now have the statutory authority to do that, whereas before most boards can't share their investigative information. You can under the compact. You can also form a joint investigation. We've had 2 joint investigations, and both of them have resulted in discipline. A joint investigation is where your board voluntarily joins other boards and your investigative staff compare and do a, as it sounds, joint investigation with other states. The one that I would like to highlight is a physician who was sexually abusing, and he was found guilty of this, sexually abusing patients. He had 10 licenses through the compact. 5 of our boards formed a joint investigation. 45 days after the joint investigation was formed, the states then issued a suspension action. The physician lost all 10 of their licenses as currently is in federal penitentiary serving his sentence for that. So it is a powerful tool that you have. The other side of that is it's not used very often. It's less than 1% of our physicians have been disciplined since 2017. The other aspect is that other state boards are very diligent in the work that they do. We've issued over 132,000 letters of qualification. Those are states of principal licenses said this physician is eligible, meets the criteria, issue a license. We've had 88 of those since as of July 31st that have been found to be invalid. Most of those are the state doing their own internal audit, finding that they missed something. Most of those related to the physician doing their GME training in Canada, not the United States, and that they took more than 3 attempts on one of the steps on their COMLEX or USMLE. There are some that there was disciplinary action issued and the licensing staff missed that, but that was reported to us. Generally, these 88 letters of qualifications that are found to be invalid were reported to us in less than 30 days of the LOQ being issued. And then the other thing that is important to California and several of other, well, it's actually important to all of our states, but those states that have shield laws, the Dobbs decision actually reinforces the idea that the compact stands for, which is each state has the sovereign right to issue a license so that a physician can practice in their state according to the requirements of that state. So if your state establishes a shield law that protects physicians providing women's reproductive health, you can do that and you can be a part of the compact and you can protect those physicians that are issued licenses through the compact. We have physicians that are licensed in states where they can perform abortions, also licensed in states where they cannot. Depending upon where that patient is located and receiving care determines which license governs the practice of medicine provided by that physician. This can exist. It also exists with gender affirming care actions, anything. Each state has the sovereign right to establish how the practice of medicine is done in their state using the license that they've issued, and no other state can tell that state what to do. So another state can't come in and say, well, you're a physician, you're licensed in California, you did something that was in a violation of our practice act, not yours, so we're going to discipline that physician. That is not a position or an action that can take place. So I will leave it at that. Some of the other things to remember is that the compact is a voluntary process. Physicians are not required to use this. If you are a physician who has concerns about getting licenses in multiple states, you can use our process and the traditional process. You can use the traditional process. There is no requirement that you use our process. We have some of our member states that on an annual basis send out as part of their shield law protections to the physicians telling them that the state will protect their ability to practice and will protect them under their shield laws and give them options of what they can do to reinforce that. I won't go through the rest of those. You're certainly smart enough to read all of that. And with that, I'm happy to answer any questions, or do you have any comments, Mr. Mesters?
Just a couple. I have been the general counsel for the Interstate Medical Licensure Compact Commission for all of its existence, which is now nearly 10 years. But before that, I spent 25 years working for the Council of State Governments Interstate Compact Center, and have been proud to be one of the authors of the only legal treatise involving the law of interstate compacts. And incidentally, the Oregon White Paper didn't even cite my book, even though it had been published for about 10 years and renewed. They had some constitutional issues, which I find wholly insufficient and not consistent with the law, because the federal Constitution in Article 1, Section 10, Clause 3 allows states specifically to enter into these types of agreements, which are evidenced by the statutes that each state adopts. And over the course of our history, which started before the ratification of the Constitution, there are now about 300 compacts nationwide on all sorts of interstate transactions, including the occupational licensure of physicians and 13 other health professions. But these instruments originally started out as a means of resolving boundary disputes for the first 100 years of our history. Environmental matters began to be covered by these compacts. Show me a river basin or a river or a stream, and I'll show you an interstate compact that controls it. But beginning in the late 20th and early 21st century, we've used these compacts increasingly for interstate regulation of functions that are traditionally within the power of the state. So as Marshall says, this is an ultimate example of sovereignty, because you maintain your sovereignty over the practice of medicine as a result of this compact. And we are here to support that and believe that there's more than adequate evidence to contradict anything that was raised in the Oregon study. In fact, the Oregon study simply raised a lot of questions but didn't answer them, and we did. So we're happy to answer questions here today. Thank you for the opportunity to present.
Thank you. So do you have an official response to the Oregon's letter
We did, yes.
that we could receive as board members? Okay.
I think that should.
It was said to you yesterday, last night, Ms. Pines, in an email. Yes.
Well, clearly I didn't want to see that.
It was late.
But thank you. That gives us a chance to look at it. There was a slide, if we can go back, where it had the all the standards. Like, these are the 9 standards. These. So who's responsible for checking this? Is this us? We're responsible for the validation of this when the person submits the letter? Is that what I'm trying to figure out, where our role is and what your role, like, what are the 30 people that work for you do? And what do we do in this process?
Yes.
Okay.
Thank you, Madam Chair. They work hard so I can sit around and drink champagne all day. Just kidding. The way the process works is the physician completes an online application, and you can go see the application. We actually have videos that will walk you through the process. So the physician completes an application. When they've completed that application and they've selected their state or principal license, the application goes to that state or principal license. That state or principal license is ultimately responsible for determining these eligibility criteria. So let's say California is part of the compact. If a physician selects California as the state or principal license and they're a DO, they would then come to this board. Your board is then responsible for verifying from primary source all of these 9 criteria. You're paid $300 to do that. But you would do that. let's say, for example, though, and I'm from Colorado, so the Colorado Medical Board is the responsible party. That's where the physician is licensed. They fill out their application. It's submitted to the Colorado Medical Board. The Colorado Medical Board will do and verify all of these 9 steps. They will provide their legal signature on the letter of qualification that says that they've done all of these steps and they've pulled a background check and that the physician meets the criteria. They issue what is called the letter of qualification, or the LOQ. The physician then says, well, I want a license in California and Nevada and Arizona and Washington and Idaho. And I am from Iowa. There is an R in Washington. You just can't see it if you're not from Iowa. So that physician would then be issued, your board would receive the entire application. They would receive the letter of qualification. They would receive all of the core data. And we will go through a training process with the board staff on how to do all of this stuff. There's also APIs available that let system to do this. Your board then would review that information, put that information into the system, and then issue a license from the state of California. You do not re-verify this information. It's already been verified and certified by another state entity. It's true and correct.
Okay. So what do you think the projections of, if we became part of the compact, what do you think the percentage, you gave some average, but what do you think for California would be?
Yeah, I think California will, so putting on my guess hat, you will probably be between 30 and 35% of all the new licenses that you issue in a year will come through the compact. And you will probably see, so if you're issuing 100 licenses in a year, you will probably issue 120, about a 20% increase in the number of licenses. The state of Florida and the state of Texas, who are very similar in size to your board, and the state of Illinois, well, no one compares to California in issuing licenses, but those nearest in population, they increased their number of staff to be able to take for about a year. And then after a year, they reduced that number. The state of Texas, who shared that with us, they hired 10 new people to process licenses for them. After a year, they reduced that number to 5. And yet the volume continues to come into them. It's just because they can create, it really does create efficiencies in the process. Your licensing staff, rather than having to search for, where are their USMLE reports, where did they go to medical school? It's all right there. And I'm probably going too far into the weeds.
No,
They will have 2 screens.
the weeds.
One screen is our information, and the other screen is your licensing information. They're just translating the information from our screen into your screen so that they can issue that license.
Okay.
It really does become very effective and efficient.
The onboard training that you have for state boards, how long is that?
Most boards, once the legislation passes, it's about a 6 to 9 month training period. And in addition to training, meeting with your legal counsel, determining if you need to create rules, understanding. So we're available for all of these sorts of trainings, but it takes about 6 to 9 months. And we have a sandbox. I'm told by my IT people I can call it a sandbox,
Right.
where we will create accounts, and you can then see what it looks like, practice. We can actually create that right now. We don't have to wait for you to become a member board. But it takes a while for your board staff to learn how to do this. It will take a while for your attorneys to be comfortable with this process and the rules that we have. It really is, we're available to help your board and answer whatever those questions. It does take about 6 to 9 months from legislation passing to actually going live. The shortest we've ever had is about 6 months.
Okay, perfect. I think those are my questions. I might have another one. Are there any board members that have any questions?
I have a question. Thank you. This is board member Nagin Mirarabe. Gentlemen, As somebody who bridges law and medicine, I find your presentation fascinating. Thank you so much for your time and for lending the anecdotes that you did. What I did hear and what I am also seeing, being part of the Law School Council on the California State Bar, is that this is a trajectory that is running parallel. In other words, there are others who are legally inclined on this board as well and know. And for others who are not aware, the California Supreme Court just a few weeks ago, last month, approved for California State Bar applicants to now move over and take a uniform national bar exam known as Next Gen. So this is not exactly analogous, but it is running in that trajectory of people being much more open to this sort of interstate commerce that your general counsel was talking about, and coalitions and agreements and things of that nature. What I did hear in your presentation was on the patient populist side, a benefit in terms of inclusivity and accessibility. Would that be a fair statement? And then go ahead, sir.
Yes, I do believe, and it allows then California physicians and the excellent hospitals you have here and the wonderful physicians that you have here to expand their expertise around the country.
I am so
The
happy
rare
that you
disease,
expanded on that.
I'm sorry?
Not to interrupt you, I'm so happy that you added and expanded on that, because that's actually where my question was going to lead you. I also heard on the board and regulatory side that it would become far more strengthened in that process because those in your compact have your invaluable staff and expertise. Can you tell us a little bit more about the physician-centric benefits to joining such a compact?
Yes, and if I could just, Madam Chair, if I could just add so there's an organization called the Rare Disease Advocacy Group. They strongly endorse the compact and the ability of creating this patient choice of physician without regards to state boundaries. And they've got their own position paper, and I won't speak on their behalf, but that does happen. Where this really does help physicians, and that is an important thing. I would say the compact is a multi-layered process. So it helps a lot of people to be able to, it helps patients, it helps regulators, it helps physicians. But focusing on the physicians, what it does, we are very focused on providing an experience for physicians that allows them, because we all know that the favorite thing of physicians is to do administrative work. They all live to fill out forms and do online process. I'm kidding. But we've created this wallet that I mentioned, our enhanced physician portal. What that allows a physician to do is to create a delegate. So our system is designed so that a physician can delegate anyone that they choose to, or multiple people, to go into their application, to complete the application on their behalf, to provide that. Most platforms, the staff that are doing that work have to know the physician's login and their password so that they can pretend they're the physician and filling it out. Our enhanced physician portal doesn't do that. Each person working in that physician's profile has their own login, their own identification. It's tracked. The physician can know who is in their application. They can know who's filling out things. And then only the physician can sign the actual form. So it's a true delegation process that's done for that. It helps the physician because they can determine where they want to be licensed and where they want to get a license from and how they get that license. If your practice involves a lot of patients who, or a significant number of patients who their kids go off to college, and you can continue their care. You can continue to provide them with the treatment that they need. You can continue to prescribe drugs for them because you're licensed in the state where they're receiving the care. So it really is, this was designed to create a way for physicians to quickly, effectively, and safely obtain licenses to practice in multiple states. And you mentioned the Bar Association, that this process applies itself to any licensure because you are relying on another state that has already gathered all the information that you would be gathering to issue that license and certifying that what they're telling you is true and correct. So attorneys, nurses, all of those different, we're actually working with, and you mentioned AI, we're working with those different groups because this is also a process that could help with licensing AI products, all of those sorts of things. So there are lots of opportunities for it, but it really is focused on getting the physician licensed quickly and effectively. As I said, 7 to 10 days on, I like to say that one rather than the 22 days, but on 7 to 10 days, physicians will have all licenses. One of the first things that we did with, this was years ago, is that there were several organizations that didn't believe that. And so what they did is they had their physicians, this is when, telemedicine was just starting and you had to be licensed in all of the states because you didn't know where the person calling in was going to be licensed, that we had a couple of organizations that had half their physicians do the traditional method to get licensed and half to do ours. And they did find that the 7 to 10 days is pretty true. We have physicians that keep an active letter of qualification in case they need to get a license because they can do it quickly and effectively. The other thing about that benefits physicians is it is a known quantity. One of the aspects of getting licensed in the traditional process is there's a wide range of time that it can take to get a traditional license. Most states issue a license using the traditional method in about 30 to 60, possibly 90 days. There are some states that it takes 6 to 9 months to get a license through the traditional process. With our process, they know they're going to have that license. They can start their practice. They can set it up. They can know that their ability to expand their practice will happen and that they can do it under a known quantity. But
Okay.
those are some of the physician-based ones.
Okay. I have a legal question for the attorney. What if the DO board wants to move forward with this from a legislative standpoint? You know, there's someone to put forth a piece of legislation, you know, separate from Med Board. Is that possible?
You mean a different version of the bill from the DO board? Or-
Yeah. Yeah. Just can the DO board be part of the compact?
Oh, yeah.
Okay. We don't have to be in joint relationship with the medical board.
No, not at all.
Okay.
This is about the credentials and as a agency that licenses physicians, you would be equally considered part of the process in which your physicians that you license would be subject to the compact. And since it is contractual and statutory, the one thing legislators get a little antsy about is they can't drastically amend it. It has to be sufficiently similar with all the other state versions of the statute to make sure that you haven't created a problem that might jeopardize the participation in the compact. That is something we regularly do. And early on, if both boards are supportive, we would be assisting your attorneys and others to make sure we have a consistent set of statutory provisions.
Okay,
And
great.
Ms. Pines, I think we need to clarify that question, though. From my understanding is both boards have to agree
We do not
in California.
we do not have any state that is not currently part of the compact. So it's a kind of yes. So your board, the state of California would join the compact.
The state.
This creates new legislation. Your board is treated uniquely and separately. So the California Medical Board would have its own process and its own data and all. And so the answer is yes and no. Yeah.
That's why I think we need to
We
clarify.
really have not had any state that has the
Not had
MD
both
and the
boards.
DO board
Okay.
both have joined. Yes.
Both organizations are represented on the commission, so you have an equal say on how the commission decisions are made as a delegate from California. For the
So-
board and the
So we only have 2 seats on the commission.
Yeah, it's not like the Congress because it doesn't necessarily represent, I know you're 20% of the population of the US, but we have found that it works best if we have each board equally represented. And so far, that hasn't created any significant problems.
Because I know that's been one of, when I was president of the medical board, that was definitely our hesitancy for us, is given the size of our state, to only have 2 positions, or, on the commission was of concern. We had some other concerns, but I think along the way, over the years, since you've introduced the compact, we've definitely become much more amenable to the compact.
Yes, yeah, California's a member of 34 compacts, including a number of occupational licensure compacts. So every state's on average in about 30 compacts. So any state that says we don't do compacts is not being forthright, because every state has them. And
So, and Madam Chair, if I could just add to that, so we met with the California Medical Board. We've met with them twice. They met last Friday. They actually passed a resolution instructing staff to begin development of the model language. And so it was passed by a vote of 11 in favor, 1 opposed, and 1 abstention. So I think you're on the same path, and I think you're both heading the same direction, and you're asking the same questions. So that's very encouraging.
Okay.
From my side of the equation.
Great. Perfect. Are there any board members that have any questions?
Yeah, Himesh Patel here. Sorry. I am a primary care provider, so this is really something that would make the work that I do in telehealth very efficient, because as of now, I'm expected to be licensed in 26 states. And as you can imagine, it can be a very arduous process. So just to kind of, I guess, bring some relevancy to this, is that it's not just physicians that want to travel to different states and do things like that. It affects telehealth directly, because if my patient travels to Las Vegas and I don't have a Nevada license, I can't take care of them. So it really impacts us directly. And I can attest to the fact that the process of individually going through different licenses is very long, tedious, and expensive. So I just wanted to ask, how does it look right now in our legislature? I know that for a long time, Florida and California were both kind of the bigger states holding out. I know Florida now is part of the compact. How does it look right now?
Again, putting on my magic with my crystal ball, it's kind of getting cloudier and cloudier every day. But I think actually my free advice to you is that your sunset review is an excellent opportunity to include this provision in there, because it's smart governance. It will help the state of California. It will address physician shortage areas. Almost 30% of the doctors that use our process get their license so that they can practice in shortage areas. The state of Michigan, if you know maps, the Upper Peninsula of Michigan, 60% of the doctors that practice in their rural and underserved areas are licensed through the compact process. And where that really starts to make a difference, especially to patients, is if you have a rural or an underserved clinic, it's hard to get physicians there. If you use the compact process, you can get a physician that's licensed to practice in your state. That physician can then start delegating authority to nurses, to other health practitioners, and they can expand their services. In the state of Wisconsin, the upper part of Wisconsin is 2 to 3 hours away from the main physician areas of Madison and Milwaukee. It's 30 minutes from Minneapolis. And they use that, those clinics there have used it to expand the services. So it really is, I'm like the G.I. Joe dial of the 60s. You pull my string about the compact and I start yammering. So I'm sorry.
Dr. Quasi?
Yeah, thank you for your presentation. This is Faisal Kazi. I'm a neurologist in Southern California and member of the board. And thank you for your anecdotes about the interstate commerce regulations. which I suspect, in terms of professional licensing bodies had been allowed to discriminate against other economic actors within their domains. So there was some protection. There's certainly some economic protectionism that had been involved. So then I wonder, within the same light, what kind of burdens and economic movements this creates. Some of it I'm thinking out loud, some of it you've mentioned, but points that we need to consider, for example, is the $300 fee sufficient for the portion that we need to do? For example, if the state of California passes a legislation, a lot of legislations here are passed without any budgetary support. So, and then our staff will have to determine what kind of staff burden or addition of staff we'll need on our end. Or it could be vice versa, because there's a good chance that beneficiaries, well, not a good chance, but more likely that beneficiaries of this process are not just individual physicians, but are what they call big clinical businesses now, the locum tenens companies, the telehealth groups. While it's great for rural states, but it also could create a scenario where people ultimately do not ever move to Upper Peninsula in Wisconsin, because people can live in Southern California and practice medicine throughout the country. So I think those are some bigger questions. But certainly I think our focus would be to have our staff really dig deeper into what kind of burdens it creates for us and what kind of impact we have at IMLCC's regulatory processes, procedures, policies of the future, and what influence we have on that, just like, and vice versa. So more homework for you. Thank you.
So, Madam Chair, if there were actually 4 economics professors from San Jose State University that did an economic study that we were unaware of, looking at the impact of a state joining the compact, the fiscal impact, the number of physicians available to practice, and all of that. And that's published, and it's on our webpage. But they found that there is actually a positive economic impact on a state for joining the compact, not just because of the compact physicians coming in, but it will increase the number of physicians coming in so more work for the staff. But it's important to point out too that that the $300 is paid to do the state or principal license process. You've already issued a license to that physician. That's why they've selected you. The $300 has been demonstrated, and again, we look at that on an annual basis, by our boards to be sufficient to cover their additional staffing, because again, you'll be processing, let's say 10 a week at $3,000 per for those. The other aspect of that, though, is that it does impact and help all physicians. We've had several states, the state of Illinois, for example, they did a fee holiday for 12 months where they charged physicians $0 to obtain a license in the state, whether they were through the compact or not. Montana is currently wrapping up their renewal period. We've had, and now that I've said that, I don't know the exact number, but 4 to 5 states that have charged $0 for renewals. We've had at least that many states that have actually reduced their costs because the volume then starts to replace the need for that. But that's something, again, we respect whatever our states tell us to charge the physician for that license and for that renewal. So you will receive 100% of those costs.
I wanted to mention the antitrust issues that you raised. The Federal Trade Commission sponsored an economic roundtable. I made a presentation to it, and they identified these compacts as a method of ameliorating antitrust concerns because of the opportunities and competitive aspects of the compact. So we could provide you with that paper as well.
Sir. Thank you for this presentation. My question is, you talked about the onboarding and training that would require. How is that something that the board would be able to work into a budgetary kind of perspective? Because you're talking staffing time. Our current staffing time was already busy licensing new licensees, depending on time of the year, especially. So my question is, where does the funding for that, say, 9-month onboarding come from? And then how how do you assist states that are coming into this program with planning that out in advance?
Yeah, so we do our onboarding at the pace determined by our member boards. So it's not something we dictate to them, but we do have an outlined plan of how to do that. The process, the training process itself, is 5 1-hour sessions that we can either do in person or via Zoom. But then it becomes Ms. Calderon's and her staff's, how much homework do they need to do? What sort of processes? But we are there to help them through that entire process. And again, I can't provide 100% guarantee, but we haven't had any member boards that have not been able to do the process and do it at their pace, fitting it into their schedule and their process. We did not provide money though for the training, so that would again have to come out of your own budget. But again, we do it at your pace. So if the California Deal Board wants to meet once a month for 3 months for an hour at a time, we can do that. If you want to meet every day for 2 weeks, we can certainly do that too. It's done at your pace. The other thing that we have available is we've created a scholarship process where we can pay the costs for API development. So if your board wants to create an API process to electronically receive the applications, have them processed, reviewed, and then approved by staff, which significantly increases their effectiveness, we have scholarships available to be able to pay for that development cost. It becomes possible because, again, the compact becomes a part of your state government. We are part of all of the states, and therefore you're not getting money from some alien or foreign entity. You are receiving them from within this. So the real answer to that is we will do whatever it takes and whatever your board asks of us to help them through the process. And we've done that consistently. We also have, and we had a recent example of this. One of our states, Alabama, created a state-based CE requirement that was different and unique. We have about 10 customer service staff that just help physicians and boards answer questions. We reached out to all 130, 140 physicians that were doing their renewal in that state, contacted each one of them directly to be able to do that. And if you'll pardon the language, one of our sayings that when we start working with staff is, if you spend more than 30 seconds or you start using profanity, you need to call us so that we can help you work through the process, because that's one of the things that we offer that. So I think it will take time, it will take effort, but I think you will find that it's done at your pace in accordance to your constraints.
Do we have any other board members? Any
Yeah, just
comments?
a comment.
yes.
This is board member John Cummins. I think you could argue that compacts by their very nature involve the ceding of some control to the compact organization. And so one of the things that I am thinking about is what areas of control would the state of California be ceding, and how would that impact patient safety? And I think you alluded, or you mentioned, that Oregon produced a white paper. There were a number of concerns raised in the white paper. I haven't had a chance to read the reply because we got it late last night. But that is an area that I am interested in, and I appreciate your willingness to respond to questions if the board has questions. I appreciate your willingness to do that.
Let me just briefly respond to the sovereignty question. What the compact asked the state to give up is the right to act unilaterally. In order to achieve uniformity, you need to agree that we're going to follow this process that leads to expedited licensure. And we believe it's done in a way that doesn't interfere with the sovereignty that you have over the license itself, but may require some procedural changes in the way the work's done, just to make sure it gets done in a way that's efficient. But we can provide more detail if you'd like.
Yeah, that could be helpful. I mean, I'm looking at California Business and Professions Code, Section 852, and kind of thinking about the interplay between that and the commission. Um, but again, that, your willingness to answer questions, I think, is helpful and may help us to identify whether there are any areas where seating control would impact patient safety, the protection of the public, basically.
Ms. Calderon has a few questions.
Thank you, Ms. Pines. So Dr. Causey, thank you for pointing out the staff and our concerns. I do have a list of a couple of questions, and if we don't have responses for them, you and I can connect at a later time. Just as background, 3 years ago, 4 years ago, this board was averaging about 8 months to license a physician. We're happy to announce that if all of the documentation is received through the traditional way, we're at 3 to 5 days right now. There is some applications where we're missing MBOME scores, or we're missing a transcript from a university. But for the most part, we're averaging close to, on average, taking into account both scenarios, 2 weeks max right now. So we're in pretty good shape. My main concern is we really only have 2 licensing analysts for the entire state, and we are taking in roughly about 2,000 new applications annually. So we're already sort of on that verge where we can barely handle what we have, right? In addition to that, we have budgetary concerns right now. On our enforcement side, we are overexpending a lot of our funds where we're having to do augmentations. So this is not something that I foresee that we're gonna, push through in the next 6 months or anything. So I love the presentation. I love hearing all the options that we have, and especially for the underserved population. This is going to be huge. We understand that. So patient concerns for underserved areas is tremendously needed. But I do have some concerns on the enforcement side. Going back to the slide, I think we still have it up here on no active investigations. I guess my first question on that, Mr. Smith, is the primary board is looking to see if there's any active investigations within that board. So like for us, California. We have experienced physicians that have left California to avoid discipline. What is other states doing in terms of verifying? I know we ourselves, when we're processing an application, we ask for letters of good standing from the other boards, but investigations are confidential. We may or may not know that. Is there a process that other boards or other states have implemented to verify the other states' investigations that might be pending?
Yeah, so that's really a two-part question. So the part regarding the acting as the state or principal license and looking at investigation. So the physician does not have licenses in these other states. So obviously there would not be an investigation. And it is, again, as the state or principal license, you are looking for any active investigations that you may know about. And as you point out, a state doing an investigation is under no obligation to disclose that. There are some states where investigations are public information and that would be available to you. But generally, these are physicians that are licensed in their state or principal license, and they're trying to get the letter of qualification so they can get licensed in other states. So there's really only that state or principal license where the investigation.
But they may already hold licenses in other states. So it's mainly the question for those. Could there be potential investigations pending in those other states that they hold licenses?
Yes, and it's the same, you run the same risk whether it's the IMLCC or a traditional process. If that board cannot disclose to you that there's an active investigation, then you are blind to that, and the commission would be blind to that. But so again, this is where the system that we've created becomes, in a sense, self-policing. If you are a physician and you are under investigation and you have the potential that you might be disciplined, if you proceed through the compact process and you are issued licenses, you will lose all of those licenses, because as soon as you are disciplined and that public discipline is reported to the National Practitioner Data Bank, your eligibility to continue in the process is ended. So I don't have a hard answer for that. The other part to it, though, in the second part of the question, is that the compact will actually create additional efficiencies for you when it comes to investigations. So as a part of the compact, you have the ability to share confidential investigative files with other boards through a process that we have established. It's delivered under seal. Your board investigative staff deal directly with the other board's investigative staff. Compact is not involved in it other than to establish that, but it creates efficiencies for you to be able to do your investigation. And as I mentioned, there's the ability to do a joint investigation. But the other part to that I think is important is 175 physicians since 2017 have been disciplined out of 65,000. It's less than 1%. So it will not, boards that have been concerned that it's going to increase their investigative responsibility have actually found the opposite to be true.
Thank you. My other question is in terms of, you mentioned that we would be able to interact with our system, Breeze. I don't know if that was shared with you. We use a system called Breeze. How will that interact? So for us, Breeze right now is also linked to License Lookup, which we post our discipline. My first question is, for transparency to the public, would we be able to, through our Breeze system, indicate that this doctor is licensed through the compact? That's my first question. And then if they do get terminated, how are other states disclosing that termination for public viewing? That's the two questions.
So with regards to the system interface, so I have a cell phone that I've had since 2015. So that gives you the idea of that you're not hearing this from an IT expert. But what happens is that we publish what is called our developer guide. So what we do in the API process is we publish this document so that your programmers can look at that document, and it says, okay, last name is found in this place in the document that we provide. So there's this interchange that allows our system to interact with your system without having the two systems have to communicate with each other. In other words, when an application is completed, it's put out there, your system draws it down and then inputs it into your system. We've worked with, we currently have about 20 of our member boards of the 59 that are using the API process. So it is actually, programmers and developers understand this a lot better than I do, and that I imagine most of you do. It's pretty easy, and it's pretty simple in that it's straightforward. It's complex. It does require programming. Your programmers will have to do work. Ours will too. But there's a process that we've got established to do that, and it will make you more effective and more efficient. And I'm sorry, what was the second part of the question?
The discipline component, like if they are terminated from the compact for transparency purposes, my question, I guess, was, could we disclose that ourselves through our interface, or is there an active registry for consumers to be able to log in and look up their physician?
So we do not, the commission itself does not maintain a database So all of our data that's in our system belongs to each member board. We don't have that. So yes, your system and your reporting system of discipline would be the system by which that would be done, just as it is for all of the other states. If discipline is issued, your board then has the ability to determine whether you wish that physician to continue to practice in your state. They can't use our process anymore. You can determine if you want to convert that, and I'm using terms that there is actually, we would work with you on how to do this. But let's say you have a physician who is disciplined because they failed to take a left-handed underwater basket weaving course for the continuing education, but California doesn't require that. So you may look at that discipline issued by another state and determine you still want that physician to practice in California. We can then work with you to convert that license over to a traditional license process. The exception to all of that is because we have created this network of nationwide physician practice. If a physician is suspended, terminated, or action is taken against their license, all member states must immediately place the license they've issued through the compact process in that same status. And they must then investigate whether they wish to continue that investigation, whether they wish to issue similar discipline, or whether they wish to dismiss the disciplinary matter. So again, it leaves the authority back to your board, but because of if it's believed, and we've got this in our rules and statutes, if a physician has lost their ability to practice in the United States, every single license issued through the compact has to be placed in a suspension status while that's being investigated and determining what to go forward. Your disciplinary process and your reporting process will not change because you're part of the compact. You're still going to be required under your state statute on how you report that information, how it's made available to the public. What does happen is within 48 hours of another board taking a disciplinary action, you will know about it and you'll have a copy of that board's disciplinary action. And your investigative staff can contact that other board and get their investigative information. It's delivered under seal. Yeah, and again, the compact itself is not involved in that. We connect your investigators with those other board investigators. It gives you an additional tool and will actually speed up your investigative process.
So just so I understand, there's a chance for suspension to happen even before it gets revoked. So we would be notified that a state suspended their license while they're on an investigation route, and then we can join the investigation.
That's correct.
Okay. I do have a question about that. Joint investigations. I mean, that's something that we don't even handle, without an MOU here in California with other healing our boards. I love the idea of joint investigation, but how is do you know, how is the cost associated with investigations that are joined? Are all the boards or all the states that are joining splitting the cost? Do you know how that works?
As I mentioned, we've had 2 joint investigations that have taken place. So again, those are decisions that are made by boards in determining whether they will join a joint investigation. The one that I mentioned, the physician who was sexually abusing patients, there were 10 states that were part of the compact that had been issued licenses. 5 of those states chose to join the joint investigation. It's a voluntary activity on behalf of your board. So you can determine with those other boards, this is how we're going to share the cost. The compact does not do anything other than create the process to happen. Once it happens, it's up to the states that are joining that to determine how you share information, how you ensure the documents are protected in the sharing, all of that is established by the board. So there could be cost sharing if that's how you choose to do it. It could be you absorb all of your costs and everybody absorbs theirs. Again, it's very unstructured other than the fact that it's permitted. And your board deals directly with the other board's investigative staff. We're not the middleman in that. Does that make sense?
Yes, thank you. I do have 3 more questions, so bear with me. Um, my other question is in terms of the, termination of the compact. You mentioned that the doctor will have the ability to apply through the traditional way. In California, when we have a physician who's had a surrendered license or revocation, we actually have a process called the petition process for reinstatement rights. Are other states handling? So when we talk about the traditional way, it's going through licensing again and having licensing verify. If there's a concern with discipline, I would think that this board would want to handle it. And I guess it's a question for both our board members here and for you, Mr. Smith, is how are other states going through like a petition? I am aware that certain states, even when they discipline their doctors, they're in front of the board. Some of them, smaller, states handle it that way. For us, we have a pathway where we send our matters to the Attorney General, who will then file an accusation. In this instance, if there are concerns with safety, have you seen, instead of going the traditional pathway, some states going through like a petition where they can come in front of the board and plead their case to get relicensed?
Yeah, so there are 2 aspects of that. So one is, and I think it's the key, your board determines whether how you do that and the way that you wish to have that happen. There are 59 member boards that are part of the compact. There are 59 different ways that gets handled. That again is your authority. You've issued the license. We've dictated the process, but you've issued that license. And so therefore your board has that determination. A lot of the decisions by boards as to whether they wish to reinstate a license that they've suspended is again up to their board. The other aspect that we run into frequently is a physician, let's say, has held a California license in the past, and now they've let it lapse, not related to discipline, but they've let it lapse, and now they're applying for a license and they use the compact process. There are 2 methods by which our boards follow. One is and it depends upon your reinstatement statutes in your state. If your reinstatement says you can just apply for a new license and we'll give you a new license number and you go ahead, you can do that. If it says you have to go through a reinstatement process of your old license, then our process steps away and your process steps into that because we're not, again, telling you how you reinstate a license that you previously issued. So there are a lot of nuances to this, but basically the basic answer is your board will be involved in the decision and the process. If there are things that the compact, if, for example, the statute requires that if you've issued discipline, you must share your investigative information with other boards. If you have an open, active investigation, you may share that information. So if another board comes to you that says, California, you issued a disciplinary action, and your board says, no, we don't want to share that, we would then go to the enforcement requirement saying you must share it. But other than that, it's really up to your board on how you do that. Most of the reinstatement actions that are taken, and there aren't that many of them, but they relate to issues that are not applicable to that state. They can't use, again, if they're disciplined, if a physician is disciplined, they cannot use our process. They lose all of their licenses at renewal or immediately, depending upon how your board chooses to handle that. Most of them relate to matters that aren't discipline in your state. So another state has issued discipline, but it's not applicable to California. And so your board has to make a decision whether you want to allow them to do that or not. So I wish I had A, B, C, and D, but there really isn't. It's up to your board.
Perfect. Thank you. In terms of fingerprinting, so fingerprinting, the subsequent arrest notifications that we receive here in California once they're licensed and they get arrested, and then ultimately convicted. Um, the fingerprinting subsequent arrest notifications would be delivered to um, the primary licensure state in this case. Is that the answer to that? And then secondly, because so there's, concerns with that. Investigations take a long time sometimes to go through the discipline process. Relying on another state to suspend the compact privilege is my concern for safety in California. Could there be a possibility that at least the arrest notifications can come to us as well?
Yeah, so there are, and again, it's every state and every board has a different process. So the state or principal license does the fingerprint background check, and they require, it's an FBI process. Not all states have that process where they get notified of subsequent. There are many states that they have to submit a new fingerprint card every time they want to get that information. There are some of our states that do have a similar process. Colorado is one of them. New Jersey is another. We've worked with that state to create a fingerprint. So you do not have the fingerprints. You do not have the records. And part of the process for the compact is we don't know the reason that a state or principal license would refuse to issue a letter of qualification. We just know that they didn't. And we have to do that because we can't have access to the MPDB. We can't have access to the FBI background information. So all we know as an organization is that their application was declined. We have worked with states on a state-by-state basis, and I'll use New Jersey as the example. They require that every applicant get a fingerprint based background check so that it can go into their system so they can be notified of subsequent arrests. Well, under the compact process, the state or principal license got those fingerprints and New Jersey did not. So what they do is during their renewal process, they require that the physician submit fingerprints to them at that point, and then they can receive that notification going forward. So there are ways we can work through that, but again, it would be unique to whatever your state needs.
Yeah, and just to clarify, in California, we do ask that question at their renewal. Has there been any arrest or convictions? The problem is that we have encountered physicians that have not come forward and disclose that information.
We have a way that we can make that happen.
Thank you. Thank you. I appreciate it. And then these are easy questions in the last two. Has there been any survey to DOs nationally to see if there's any interest in the compact from your organization in particular? So that would be something that I think we would need to do here in California just to see, just to kind of give you an idea. Nationally, we have roughly about 200 total physicians, a little over 200 active physicians that are DOs. The majority are here in California, just like the medical board, but just in comparison, that's how many California Medical Board has alone. So there is a different demographic. Not sure of the interest component. So that would be something that I think we would want to look into, is the interest. Because what we have experienced on our side is a lot of physicians leaving the state and not wishing to renew their license. So the interest, one of the questions I think would be, what's the interest look like? And, for what I'm hearing is the benefit side is they'll be ready to go if they get a job opportunity that comes, or if they want to come and help. Also the telehealth component. But there is, on my side, there's an interest in knowing how much we're going to get hit, because I did mention that only the two analysts. So we would have to prepare for that in advance. For us, it would be detrimental to bring in an influx of physicians all at once and not be able to support it on our side.
Yeah, the thing is, there is often a concern about flight of physicians out of a state. And that's if it happened in California, you would be the first state where that's happened. Actually, what it does is it helps your physicians that are located here expand their practice into other states. And so what we found is they tend to stay where they're currently located because they can now expand their practice. Half of our physicians half of the physicians that use the compact process, it's about 48%, do it so that they can do telemedicine and locum tenens work. The other half are so that they can expand their practice. Nevada, California, hopefully we bring Oregon in and you can have them in there too. But I think what I would suggest to you is that should California join, the onboarding process will be done at your pace and the pace in which you are comfortable moving this forward. The medical board will do their own process and their own onboarding and their own pace. You are treated as a unique entity in our process. Interest level, we are reaching out to the California Medical Board and the California, I'm assuming you have a California DO board. I haven't done my research into that yet. But the national organization, the AMA and the name ran away from me. But the national organizations are in favor of joining the compact, and they are supportive at a national level. Each individual state can make its own decision, but there is an interest in doing this. And I do think if you did join, you will see a significant increase in the number of licensees that your state will have to do. And again, we will walk you through that process and be able to. In other words, if something happens, it's not because we haven't talked to you about it. It's not because we're not working with you through it. You're going to be well aware of what's going to happen, and we've got information and all sorts of things and I'm promising things, and I will deliver on them.
Thank you.
I won't. My staff will, but
Thank you. That's all my questions.
That's great. And Dr. Quasi, did that answer a bit of your concern around control? Okay, perfect. Are there any other questions by board members before I go to the audience?
I have some follow-up questions, President Pines. To follow up on executive director's questions, I'm curious what happens, or let me back up here. I think the pause for concern, everybody can hear the benefits and has seen the benefits in the states that you've mentioned with the compact. I think the underlying pause for concern is really a collective action problem. You have a process in play, but then individually states have to deal with the enforcement. And for highly sought after states of licensure, such as California and New York, where, as you have admitted and estimated, there would be a great increase. What would be the safeguard against any modifications to that process? Is the compact open to that? Is that even possible? Because that would have to be modified across all of these states. Is this also, in other words, a malleable and flexible process? We have heard that you would be working with the individual state to deal with the existing process. But is there an option for states who have a pause for concern of this, again, potential collective action problem, to be able to amend that process moving forward to be of benefit to all?
yeah, I don't know. I really, it seems like a broad question. So changing the compact, let me cover it that way, and let me know if I've addressed your concern. To change the compact statutory language requires that all states would pass a similar, because again, this is an agreement between the states. What we've really found is that our member states, so it to me, it's kind of that two-edged sword. Oftentimes states want a very established process that tells them this: if X, then Y; if Z, then A. And yet at the same time, they don't want the compact or other states telling them what to do. And so we try to balance that in all of these aspects. And again, I go back to the idea that these are highly qualified, high bar standard physicians that are meeting this practice. They're at jeopardy. That 175 physicians that have been disciplined out of the 65,000, they've lost. Those 175 physicians ended up with 365 disciplinary actions being taken against them by all of the different boards that they've issued a license. They've lost. If the average is 4 and you have 200 physicians that have been disciplined, they've lost 800 licenses. It's a high stakes process for the physician to do this. It costs a lot of money for them to do this. They don't do it lightly. If you've got a physician who is right on that edge of good practice versus disciplinary level practice, they're not going to use the compact process. It's just too much at risk. So, and it's also, again, there are not that many physicians that have been disciplined through our process. As I said, 175 in 10 years. That's a pretty good record. And I'm more than happy to share with you, Ms. Calderon, the redacted list of these physicians and the reasons that they've been disciplined. I'm happy to share that with you. So I think the process is amenable to making this work for each state, but it also is an obligation on all of our states to do that. It's that double-edged sword. If you want the freedom to do it, then you have to take the responsibility for that. If you want us to tell you how to do it, we would need to do that, and it would need to be the collective will of all the boards and the commission.
Okay. Lastly, is there any published paper by New York regarding their hesitancy to join the compact?
No, they have not published. The bill has been introduced there 3 times. Their last concern, so we had the support of the governor's office, the attorney general's office, the medical society, the DO society, the hospital association. There was broad support. New York has a unique licensure process in that to be issued a medical license to practice in New York, you have to go through the Department of Higher Education. And the Department of Higher Education, the Regents, the New York Board of Regents to issue that license, and they are opposed to changing their licensure process. They have not published that. There is no public statement, but each of the 3 times we've introduced the bill, it's moved forward, and then it dies. So, yeah.
Thank you.
Ms. Pines, one last question. Mr. Smith, I just thought about this. Is there a committee within the compact that executive directors can participate, bring concerns, be involved with if there are, especially on the discipline component, like data sharing of information, making sure that if concerns occur, we can collaborate and help improve the system within the boards. I understand that from what I'm hearing, it's we drive this, right? We're the ones that are making sure that we're disclosing anything that happens within our state. So if there are concerns that are happening along the way, is there a committee that exists that we can be involved here in California?
So every commissioner serves on an active committee.
Okay.
We have let me see if I can remember them all. We have a personnel committee, we have a budget committee, we have a rules and administrative procedures, we have a technology, and we have a communications committee. The rules and administrative procedures is probably closest to what you're talking about. They look at our rules, they look at our processes that we've established and that we require of all of our boards. All of our meetings are open to the public. Every commissioner can attend as many meetings as they want to. But ultimately, it is the executive committee that that provides the guidance to staff, very much like your board, and they can act on behalf of the commission should they need to. And they meet on a monthly basis. The other aspect of the commission is that any commissioner can bring any item for discussion by the entire commission or to the executive committee. So every commissioner has the ability to do that. So the answer to that is yes. Any commissioner and staff. We have a monthly meeting with licensing staff where we talk about issues and concerns that they have. It's a closed meeting, only open to licensing staff. Yes. So there are plenty that if you're not feeling heard, it's because you're not participating. Yes.
Thank you. Okay, do we have any question, any additional comments? Board members going once, twice? Okay. Holly?
Holly McChris, Executive Director, Osteopathic Physicians and Surgeons in California. I'll direct my questions to Erica in an email because I know that's what you want to do. But all I'm going to ask of the board is that you be transparent in your process of how you get to the spaces that you'll get to. Please share ahead of time. We do know that there'll be costs that will be coming to the physicians that they'll need to be aware of. You have a lot of costs that you're bringing up already, right? Moving forward through the regs. So if you can just work with us or let us be have the information available so that we can digest it early enough to come back with any comments. If there are comments, I can sense the excitement about it. I get that. And I can see how it's been exciting and great in other states. And it's great for telemedicine. It's great for locums. But we are a unique state and we do have a lot of physicians like coming here. I mean, look at how many licenses have developed in the osteopathic world in the state of California. I mean, we're the largest state with osteopathic physicians practicing, right? So I just want to make sure that when we look at this and we take into consideration our physicians that are currently here and how they are practicing, and that we're not just opening up a gateway for physicians from other states to just have a license here, but do nothing with that license. I understand the eagerness to have a license to go across state. I get that. We have many physicians that do that already. So I understand all of it. We just want to make sure that we're looking at every aspect of it and we're patient safety always first. Thank you.
Thank you. Moderator, is there any persons online that would like to make a comment?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and I do have several requests. I'll go in the order received. First, I have Michelle Montserrat Ramos, and Michelle, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Good afternoon. I'm Michelle Montserrat Ramos, and I'm with Consumer Watchdog. We agree completely with the previous speaker that in California, patient safety should come first. If a physician was denied a traditional license in another state, California would be required or obligated to issue the license. A few dangerous doctors here are a few too many. A few dangerous doctors in California amounts to significant harm. You have heard it here in your meetings from families who have come forward testifying of many lives lost due to the same physician. There's no data that determines that the compact doctors are squeaky clean. If a doctor's license becomes delinquent in their principal state, unless the delinquency results in disciplinary action or a restriction placed on the license, this would not be considered a disqualifying event, and California would have to issue the license. We have seen situations where a doctor is facing discipline in his home state, and he will move to another state and seek a license there before their disciplinary action goes into effect. This license compact will make it easier for physicians to move from state to state to maintain a license. The problem with doing so is that nothing can really be done about that compact license until it's up for renewal, and even that is questionable. As advocates, we are here to protect California patients. We believe that your board is more apt to protect consumers than others and are doing so now, fixing prior issues. We're asking you to place patient safety first by supporting consumer protection and not supporting the interstate compact. Thank you.
All right, this is the moderator. Next, I have Kimberly Turbin. And Kimberly, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, can you hear me?
Yes.
Okay, I'm Kimberly Turbin. I'm from Reseda and a volunteer with Consumer Watchdog. As patient advocates, our focus is on consumer protection. The Interstate Compact does not provide protection for consumers. Our concerns include the public protections regarding investigations, subpoena enforcements, and sharing of disciplinary information are protected and controlled. The problem is that the two boards decide how they want to share information. It is not established that the boards are required to share all information with the state board that is reviewing a compact physician. This is an issue that will not protect California patients. If a physician who is denied a traditional license in another state, California would be required or obligated to issue the license. A few dangerous doctors here are a few too many. A few dangerous doctors in California amounts to a significant harm. You have heard it here in your meetings from families who have come forward to testify of many lives lost due to the same physician. This is not about acquiring more fees. It is not about a proposed future shortage of physicians. This board is required to protect consumers and the Interstate Compact does not do so. We are urging you not to support moving forward the Interstate Compact. Thank you.
This is the moderator for members of the public on WebEx. Next, we have Maria Ibarra Navarrete. And Maria, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Good morning. My name is Maria Ibarra Navarrete. I am from San Jose, a volunteer with Consumers Watchdog. I became a passionate advocate after the tragic loss of my brother due to preventable medical negligence at not one, but two medical institutions. In response, I filed formal complaints with both your board and the medical board, hoping to initiate change. Through this journey, I have discovered just how limited our rights are as families facing these challenges. We participate in these meetings to advocate for improvements that will create a fairer system for families, ensuring that no one else has to endure such heartbreak. The Compact provides an avenue for physicians to pursue licenses in multiple states, but it does little to nothing to protect consumers. This should be an issue for you as well. One of our biggest concerns is how the two states manage sharing information once one state determines that they need to review and investigate a doctor. The IMLCC makes the connection between the two states, but the connection investigative staff determines the process of sharing and exchanging information. The information is shared under the defined standard of confidential and filed under seal. There should be a standard protocol that if a doctor is being reviewed and under investigation in another state, then all materials must be required to be shared between states. That is the only way that you can protect consumers in both states. When doctors know that they are facing discipline, they can go ahead and file the licenses in other states. They can do this before their disciplinary actions is enforced. We all know how long it takes to go through the enforcement process. This puts California patients at risk. I would like to believe that this board places a higher focus on the consumer protection. This is not about collecting more revenue. This is not about licensing more physicians for a future potential physician shortage. We have projects like Mexico Physician Project, where California boards fully vet and monitor the progress of those physicians. Our focus is to protect consumers above everything else. Please show Californians that you are putting our families first. Please do not support the Interstate Compact. Thank you.
All right, this is the moderator. One second. Next, I have Lucas Evanson. And Lucas, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, my name is Lucas Evanson, speaking on behalf of the California Medical Association. CMA appreciates the board's decision to bring this item up for discussion and consideration. California physicians want a licensing process based on education, training, experience, and ethical criteria, and also one that avoids unreasonable delay in application processing. Today's presentation makes the case that the IMLC accomplishes that. We do, however, think that given its one-size-fits-all approach and the unwieldy process for withdrawing from the compact, that careful evaluation is needed before any decision about joining the compact can be made. Since the Dobbs decision, California has passed multiple pieces of legislation that seek to protect California physicians from activist enforcement by other states that have different laws around abortion and gender-affirming care. The compact language allows member states to conduct joint investigations, issue subpoenas enforceable in other states, and impose reciprocal discipline across state lines. Section 10D of the compact also requires the automatic suspension of licenses in other member states for 90 days based solely on disciplinary action taken elsewhere, before California independently evaluates the underlying conduct. Finally, pursuant to Section 24B, any California law in conflict with the compact is superseded by the compact. We encourage the board to fully explore what those provisions could mean for California physicians. Just because there has yet to be an issue does not mean that there would not be an issue. We also encourage the board to fully explore the cost and workload requirements associated with joining the compact. Would the $300 provided to a state of principal license by the IMLCC cover the board's costs to process letters of qualification? Are there additional costs the board would bear for administering the other requirements of the compact that are not covered by the fee? What is the estimated cost for performing those? How would the workload associated with the compact applications and administration impact processing of applications filed outside the compact process? Thank you for your diligent review of all the aspects, both the potential risks and benefits of joining the IMLC.
All right, this is the moderator. It appears we have no further requests for public comment at this time.
Okay, great. Thank you for all your comments. We heard them. Thank you, Mr. Smith, for your presentation and the rounds of questions that we have all had. We are now going to move to lunch. I know we have another presentation, but it is now 12:27. So let's return at 1 p.m. And we will then be joined by Dr. Thatcher and Ms. Creason for their presentation on agenda item number 9. So we'll return in 30 minutes. I want to welcome everyone back to the Osteopathic Medical Board of California board meeting on August 25th, 2026. We are going to start with a roll call to make sure we have all our board members present. Machiko, can you take the roll?
Dr. Walsh. Dr. Swain.
Present.
Dr. Causey. Madam President, Board Pines.
Present.
That came out wrong, I'm sorry. Dr. Patel.
Here.
Nagin Mayor Hobby.
Present.
Dr. Lockman.
Present.
John Cummins.
Present.
Gore Damian. A quorum has been established.
Great. We left off at moving to agenda item 9. So that's where we are at right now. We're going to have an update from the American Osteopathic Association, led by Richard Thatcher and DO, and CEO of the AOA, Kathleen Creason. You both may begin your presentation.
Thank you very much. Are you able to hear me all right?
Yes.
Very good. Thank you. And unfortunately, Dr. Thacker is not going to be able to join us this afternoon. He was hoping to do so, but he had a flight that actually just left. So
Okay.
he sends his regards and his apologies, and I'll be making the presentation. And if you have any questions that we need to follow up with, we certainly can do so. But I wanted to thank you for the opportunity to speak before you today. As many of you may know, I was previously in Holly McChrys's position as Executive Director of OPSC for 15 years. And I am still a California resident, even though I work in Chicago. So it makes a little bit of a commute. But I went to many, many OMBC meetings, and it is a pleasure to be here before you in this role. So wanted to take a little bit of time. So it's somebody advancing the slides. Do I just need to tell you when to go to the next one?
It's Machiko, Kathleen. I am. So just
Oh.
let me know when you're going to when you want me to advance.
Hi, Machiko. Thank you. So the next slide is strategy and purpose. So if you can go ahead. And this is just for your information to give you kind of an overview of the AOA. This is our brand new strategic plan. And the most important piece is on the top left as it relates to osteopathic physicians, as the AOA exists to support the career journey of osteopathic physicians and students around the world. And that includes obviously the large number of osteopathic physicians in California. We're also working very hard to ensure that we communicate the value of osteopathic medicine, both internally and externally, strengthening the osteopathic body of knowledge through education and research, which, as you know, is very important, and then investing in physician leadership. So if you'll go ahead and advance, and even one more slide. Thank you, Machiko. So we wanted to talk a little bit about the AOA CME credit system, because I know previously you received information on some other credit systems and wanted to just give you some background information to make sure that you had a full understanding of the AOA's involvement. So starting with why AOA credit matters, you can see 13% of all licensed physicians are DOs. More than 25% of all osteopathic medical students are um, are. Sorry, I realized that I jumped a slide on my side so much ago. If you wouldn't mind backing up a moment, thank you. So the AOA CME credit system. So as you very likely know, AOA maintains a nationally recognized CME system that supports licensure, state licensure, certification, and lifelong learning. So AOA is one of 3 physician credit systems in the US: AOA, AMA, and AAFP. So thanks. Now we'll go to the next slide. Sorry, I jumped ahead of myself. So more than 25% of all medical students in the US are osteopathic medical students, growing exponentially. As you know, you've got 3 schools in California, and 20% of all GME trainees in the US are DOs. 38% of military physicians are osteopathic physicians, and a full 31% of osteopathic physicians practice in medically underserved areas. So that's one of the reasons, as we all know, California has pretty extensive medically underserved areas. So the osteopathic profession is very, very important in the state. Thank you, Majiko. You're right. You're right on top of things. So again, just to give some overall numbers, the AOA has 47 state affiliates that are part of our network, plus 26 specialty affiliates, colleges of osteopathic medicine, hospitals, and stakeholder organizations. So you can see on below the line 2025 CME, just to give you some information about our activities. We had almost 3,600 1A activities accredited in the past year, over 91,000 learner interactions, almost 30,000 unique learners, and over 800,000 credits awarded. So pretty significant numbers. So just to speak about licensure and osteopathic continuous certification, again, as you may know, the AOA provides a centralized CME transcript for all DOs, regardless of whether they're an AOA member or not. And any osteopathic physician can utilize this transcript for both state licensure and osteopathic continuous certification, so board certification. The AOA accredited sponsors can index the CME activities for state required topics. So anything that any state requires, including I know California has some specific topic areas that are required for osteopathic licensure, those can be indexed on that the document, the transcript that the osteopathic physicians have access to. So the support for licensure and OCC, again, osteopathic boards, certifying boards, they accept a combination of AOA Category 1A and AMA PRA Category 1 credit for their in-specialty CME requirements. So as you likely know, osteopathic physician, if they are board certified, they have to comply with the state licensure requirement, CME requirements, and osteopathic board certification or allopathic board certification requirements. The AOA also maintains ACCME accreditation so that physicians, again, if they want or need the allopathic credit, they can apply through the AOA as well. And we serve as a joint provider for a number of different activities, again, making AOA CME activities as accessible to physicians as possible. So using CME tracking utilities for licensure. So again, I know you've received some information on various CME tracking utilities. So just want to make sure you have complete information on this. So there is an operational impact if a CME tracking utility is used for licensure boards. There's an impact for the CME provider and for the physicians themselves. There's not always transparency of costs to both the physician and the CME provider, so that has to be very clearly articulated when considered. An important statistic, only 38% of ABMS primary boards participate in systems that track maintenance of certification. And as I indicated earlier, OCC requirements are tracked in the AOA position transcript. So if and as you consider other CME tracking utilities, it's important to understand what is the required level of the tracking utility in the state. Is it mandatory? Is it optional? Are physicians required to opt to audit it? And how are the physicians impacted by the use of the utility? And are there options for physicians to report directly based on their credentialing path and their education needs? So these are all important pieces of information to consider as you think about CME tracking utilities. So again, just taking a broader look, the AOA supports osteopathic physicians at every stage of their career, undergraduate, graduate medical education, through licensure, through board certification, through CME. Obviously, we work very closely with OPSC, our state affiliate, and provide support as needed to osteopathic physicians to make sure that they are supported at every stage of their career. So that is a general overview of the AOA, our recent areas of focus, and then again, the aspect of continuing medical education and how we provide support. So I will stop there and see if anybody has any questions that I may answer.
Sorry about that. Thank you. Are there any board members that have any questions or comments? No. Okay. Any? No. Holly goes, no. Are there any, moderator, are there any people online that would like to make a comment at this point?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and we do have a few individuals requesting public comment. First, I have Michelle Montserrat Ramos. And Michelle, you'll be given 3 minutes to speak in a 15-second warning. Please click the unmute me button when the prompt appears on your device. And this is the moderator. Michelle, if you are speaking, you're currently muted. I'll request to unmute you again. Please click the unmute me button when the prompt appears on your device.
Hi, good afternoon. I'm not sure how my hand ended up being raised, but I didn't have any comments at this time. Thank you.
Oh, I apologize. Thank you. All right, in that case, next I have Graham McCone. And Graham, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hey, good afternoon, everyone, and lovely to have a chance just to say hello and hi, Kathleen, a colleague at the AOA. Just wanted to follow up on the conversation we had last time we presented, and fundamentally, we just encourage the board not to think of this as a choice between our two systems. Both are terrific, both provide terrific value to osteopathic physicians in California. Your physicians and licensees learn in both systems, and your requirements already recognize CME from both. I would think about a DO who's an endocrinologist, a neurosurgeon, an oncologist. Much of the education they participate in, and that's most relevant for them, comes from their national specialty society, their local academic medical center, or another of the 1,500 ACCME accredited providers out there. And we should encourage physicians to choose the best education for their practice and their patients, not allow an administrative pathway to influence where they learn or what's important for them and their community. we're not asking OMBC to recognize any new category of CME. You already review and accept CME from ACCME accredited providers. We're simply offering to make that existing process digital, so the accredited provider reports the completion directly as they already do. We capture hundreds of thousands of CME credits for your licensees in our systems already, and your staff just have the option of verifying that electronically, just as they do with other credit capture systems. So the physician doesn't have to manage and submit certificates in the same way. Obviously, AOA provides great data from their terrific programs. ACCME are happy to provide ours. Accepting both gives your staff a more efficient process and gives your licensees greater choice and less administrative burden without changing any of your standards whatsoever. Thanks.
All right, this is the moderator. Appears there are no further requests for public comment at this time.
Great. Thank you for your comments. We are now going to move to agenda item number 10, the Executive Director's Report. Ms. Calderon.
Thank you, Madam Board President Pines. Before I get started with my report, I would like to take a moment to also welcome Dr. Walsh to the board. Dr. Walsh and I have crossed paths many times at OPSC conferences, and I couldn't be more thrilled to have her join our board. Dr. Walsh is also not a stranger to our board, having served as an expert for the enforcement program for several years. Welcome, Dr. Walsh, and we are looking forward to working with you. Next, I want to also welcome Secretary Chopra. I've had the pleasure of meeting Secretary Chopra in person earlier this month at one of DCA's introductory meeting with him. It's very clear that he will be actively engaged with our department, and we anticipate a positive direction under his leadership. Now for my report, this is agenda item 10, the board's executive director's report. This item provides updates on personnel, administrative functions, and ongoing projects for the Osteopathic Medical Board of California. It is an informational item only, and no action is required from the board members. For personnel update, the board currently maintains a 15.9 authorized positions. At our last meeting, we shared that our receptionist had accepted a promotional opportunity outside of the Department of Consumer Affairs. And due to noticeable increase in consumer complaints, the board has chosen to postpone filling that vacancy. The savings generated will now be redirected to hire an office technician on a limited term basis for 1 year to support our enforcement program. In the meantime, board staff are collectively covering essential office functions, including the processing of incoming mail and incoming phone calls. Additionally, the board will exercise its blanket authority to temporarily fill the enforcement analyst position. The incumbent in that position has been on an extended leave of absence for nearly a year and is due to return in mid-September. However, if the employee decides not to return, that temporary appointment will remain in place until we hear from her. Interviews were conducted for the office technician position, and interviews for the enforcement analyst will soon take place. We do hope to make offers on both positions in the upcoming weeks. Return to office. Lucy kind of touched on that earlier. On July 1st, 2026, the board implemented the statewide return to office requirements established under Governor Newsom's Executive Order N-2225. The executive order, first issued March 3rd of 2025, required agencies with the governor's administration to transition hybrid teleworking employees to a minimum of 4 in-person workdays per week. Although initially scheduled to begin on July 1st of 2025, implementation was deferred until this year. There are no issues to report on the employees' transition back. On the contrary, it's been my own personal observation that there's been a lot more teamwork and collaboration happening around the office. To help keep office morale up, we are staying current with our all-staff meetings, and we will be planning a lot of team building activities in the upcoming weeks. Please refer to the board's organizational chart for details on the staffing information. DCA's annual report. With the close of fiscal year 2025-2026, board staff have completed and submitted our annual report materials to DCA. This includes both the board's narrative report and our program-specific data summarizing the accomplishments for the year for both the licensing and enforcement programs. DCA will review our submissions prior to publishing the statewide annual report. Just as a reminder, the report provides a comprehensive overview of our operations, including board membership, staffing, licensing requirements, fees, workload and performance data, continuing education requirements, and recent legislative and regulatory changes. For administrative functions and projects, I'm going to start off with our delinquent physician and surgeon licenses. Staff continue to address issues related to the delinquent licenses. After consulting with legal counsel, it was determined that the OMBC is authorized to accept voluntary surrenders following Business and Professions Code Section 2224, similar to the Medical Board of California. We have developed a surrender application form modeled after MBC's form, now available on our website. It will remain optional until formally adopted through regulation. So we do have it on our list for upcoming regs. Voluntary surrender is not permitted if the physician is under investigation or subject to disciplinary proceedings. This process will be useful for several physicians who have left the state and have no plans to return and have allowed their license to remain delinquent prior to the cancellation of a 5-year mark. Next, Copilot. As Denise mentioned, DCA has authorized the use of Copilot and Copilot chat for the board and bureau activities. DCA established also an AI council, which I have been asked to participate in. The council is in the midst of organizing work groups to develop staff user guidelines and evaluate how Copilot may improve workflows while also considering potential risk associated with AI technologies. And just to kind of let you know, we have roughly about 4 licenses that have been issued to our board. We are co-piloting our abilities through Copilot to deliver informational materials to stakeholders, using it for responses to our emails. The licenses have just been given to leadership staff at the moment. So Christy, myself, and Machiko have licenses, and we are co-piloting a little bit of a staff engagement and early on participation through our complaint our complaint analyst position. This individual is also responsible to answer to public questions. It is a time saver that we're noticing with her usage, and slowly with obviously having more guidelines in place, we may introduce these additional licenses to other staff members. Third, to report today in terms of items here is the Department of Justice fingerprint audit. On May 5th, 2026, the board was selected by the Department of Justice for an audit. Staff participated fully in this audit, and the final findings concluded that the board was compliant in all areas assessed. Fourth, and the most important of the projects that are being reported today is sunset review process. On July 13, 2026, DCA's boards undergoing sunset review in 2027 met with legislative staff to discuss the timeline for this cycle. As a reminder, the sunset process is a positive review, which evaluates the board's performance, operations, and effectiveness. It is our time to highlight all of the positive changes this board has made over the past 4 years. And if I may say, oh boy, do we have a list to share. It also provides an opportunity for stakeholder input. Today, I would like to share a couple of key timeline highlights for the new members on the board that have not undergone the sunset review process, just so we all have an understanding of how this plays out. During spring and summer, the boards receive legislative templates and begin drafting their sunset review reports. Both Machiko and Christy can tell you that I started about 8 months ago updating that report. Our staff have begun drafting and plan to share the board's report with the executive committee prior to presenting it to our full board for approval at our November board meeting. In late winter, early spring, a background paper is issued summarizing findings from our last review. In February and March, the sunset hearings are held. The executive committee and board staff will testify, and stakeholders may also have an opportunity to make comments on the board. Post-hearing, boards have 30 days to submit a written response to issues found. And then we have our legislative action. Satisfactory boards typically receive a 4-year extension. And then there's the governor's signature. Legislation is signed, renewing the board's authority until the next sunset date. Now, I did bring to your attention that the Medical Board of California brought forward some proposals at their last board meeting, which was held this past Thursday and Friday in San Diego. At this time, board staff is not asking you to take any position or consider these as part of our proposals. However, I would like to introduce you to some for consideration. Amongst the proposals for the enforcement, there is changing the evidentiary standard for board disciplinary actions from clear and convincing to preponderance of evidence, straightening laws addressing licensees who engage in sexual misconduct, requesting further enhancements to BMP Code Section 2307, require peer review bodies to submit unredacted records with reports under BMP Code Section 805 and 805.1. Do want to touch a little bit on that one, that we believe strongly on this one on the enforcement side. We're having difficulty sometimes gathering those investigative reports, and we have to move forward with administrative subpoenas in order to gather them. And there is a time lapse before we get the reports, and so we do believe that this is a good proposal. Authorize the board to increase cost of recovery in non-adopted proposed decisions, similar to the respiratory care board. Require licensees to report restrictions imposed by courts or federal agencies post pending felony charges on licensees' profile pages. And then require the board to post civil penalty orders on licensees' profile pages and board website. And then amend timeframes for exchanging expert witness documentation to accommodate expedited hearings. For licensing, we would require, or a proposal has been made to require postgraduate training license holders to notify the board when leaving their program. On this matter, our board has already notified the Medical Board of California that this requirement should also be extended to residents that are in that wait time to complete their 36-month requirement. It has been our observation that we are seeing some residents that are being terminated right before that 36-month mark, and we're having to collect verifications from 2 programs as these individuals are seeking a different program to complete the requirement. So it is putting a little bit of a burdensome in us getting that information. So we would like to see that this measure be extended to residents as well. And then lastly, there is a repeal section code that they're proposing for BMP Code Section 2064.6, which is also tied to the postgraduate license. Following the medical board sunset proposal presentation, no motions were made regarding any of the specific proposals. Instead, members directed board staff to continue refining the proposals and submit final recommendations to the full board at their November board meeting. Our staff's intention today is to mention to you that we intend to collaborate with our executive committee first. As you know, it's Dr. Patel and Madam Board President Pines, to see if they wish to consider any of these measures for our board as well. And we would also like to collaborate with the Medical Board of California as much as possible. Now that we're both going in sunset, we believe that that is extremely important, as any measures that they may move forward that get adopted to legislation impact our board as well. Additionally, our staff invites input from all of our stakeholders to be presented today and at our November board meeting for our executive committee to consider. Board publications, communication, and outreach. The board's newest edition of its newsletter has been posted to our web. I'd like to thank Eb, who is in the audience today. He actually volunteered himself to take on the role of helping me put our newsletter together. And with his assistance, we were able to get our fall edition in summer ready to go out and get published. So thank you, Ed. You were very instrumental in putting that together. Ed is also going to take some of our content from that newsletter and use it for future publication notifications that will be used throughout our Facebook page, LinkedIn, and Twitter accounts. Staff continue updating social media accounts through EBS assistance and our board website as well with legislation, frequently asked questions, publications, and of course our enforcement actions. Machigo and I did recently meet on a couple of minor adjustments that we will be taking on for our application tab. This was from some recommendations that were brought forward from some of the postgraduate training directors on how to make it easier to find applicable forms for each license type. So we're underway on that project just to kind of reorganize the page a little bit to be more transparent in how to find the documents that they need. On May 9th, 2026, enforcement staff and I attended the 5th Annual Latina Maternal Health Fair in Kern County. I'd like to extend an offer to our consumer watchdog advocate groups that were present there. For me, it was very, very important to participate in this. Our mission couldn't be more apparent in this type of a setting. A lot of the moms, I will tell you, were extremely grateful. Future moms were extremely grateful to learn on how to look up their physician, to be informed on how to file a complaint, and really just to highlight who we are and what our mission is was extremely apparent there. On September 12, 2026, Machigo will be hosting a booth at a California Health Sciences University in Clovis. And on September 14, 2026, Ms. Pines and I will be attending a meeting on AI and the practice of medicine hosted by the Federation of State Medical Boards and the American Medical Association. Hope to learn a lot from that I can bring and share to the DCA AI Council. I'm sure they're going to love hearing about it. On September 24th, 2026, staff and I may participate. We're still waiting to see if we got accepted in the Placer Project Senior Resource Fair here in Roseville, pretty close. This event provides resources on senior wellness, emergency preparedness, and elder abuse prevention. Our presence will help educate consumers about our regulatory role, license verification, and the complaint process. I do want to point out, I'm just looking at Ralph right now. I forgot to include this in my script, Ralph, but Ralph and I also did an outreach event here locally at West Sacramento, the Rotary Club, where he and I spoke to the Rotary Club participants there about the consumer process and what to expect. It was a 2-hour event, which was lovely. Again, no one really knows what we do, and that's what we were there for, to spread the word on consumer protection, and they were very grateful. They came up to us after the presentation and thanked us for participating and also expressed how much we do and how involved we are in our in our world of protecting our consumers. And they had no idea how long of a process it can be to undergo investigations. But also just awareness, where to go to file a complaint and the resources that are available to our consumers. Lastly, the board plans to conduct their annual professional identity lecture that we have with Touro University in Mare Island. We have engaged every year, and this is a chance to talk to our students in advance before they get into the real world on how to keep their professional identity at their forefront, how to educate themselves on what to do and what not to do, and stay active in their community and involved with the board, and how we can provide also resources for them. And that will be on October 26th, following a lab on October 29th, where the students themselves will take on the role of the board and will adjudicate their own peers based on the scenarios that we present to them. In terms of communication, I continue to represent the Prescribing Boards on Cures Executive Stakeholder Committee, the DEIA Steering Committee, and now, most recently, as I mentioned, the DEA AI Council. I've engaged in ongoing discussions with President Pines regarding upcoming projects and agendas. I like to say, Ms. Pines, that Monday is the highlight when I speak to you for me. I get to interact with someone who's right there with me, who keeps me busy, who keeps on encouraging me to keep going. So it's very nice to be able to talk to you. In late April, the board received a new Attorney General Liaison, Dag Giovanni Mejia, who I hope is still listening to us. I think I saw his name pop up. We'd like to welcome you, Dag Mejia, to our family. We are grateful that we had Carolyn Westfall for so many years. But as I'm not sure if you are aware, the Attorney General likes to rotate their DAGs amongst their clients. And Giovanni has already dived right in. He's working with Yvonne, our special investigator, in a lot of cases, and has given her, really direct instructions on how to handle some of her investigations. So thank you, Giovanni. We welcome you and look forward to working with you for many years. I continue periodic meetings with our consumer watchdog patient advocate leaders to gather feedback on improving enforcement processes. Most recently, Michelle and I met and discussed our consumer closing letters when it comes to doctors that have been educated on record keeping and communication issues. We weren't as transparent in our closing letter to our consumer. And so now we made some edits to those letters, letting the consumers know and the patients that although we didn't take disciplinary action against our doctors, we did take the chance to educate them on what we consider minor violations of record keeping or communication issues. Lastly, enforcement staff continue to hold monthly meetings with our DCA's Division of Investigations Office, HQIU, to monitor an ongoing investigation progress. And I like to say that I think it's time that at our next board meeting, if they agree that they provide an update, I like to go ahead and do a yearly update from DFI. So in the future agenda items, we might see that as an update coming up. That concludes my executive report, Ms. Pines. I am happy to answer any questions that the members might have.
Thank you, Ms. Calderon. Do we have any board members that have any comments or questions? Dr. Patel?
Yeah, Himesh Patel, Eric, I wanted to thank you for all the efficiencies you've created over the last few years. Tremendous work. And I just wanted to, on the record, thank you for engaging with the community, making sure that we have lunch here, just every detail you're attentive to. So thank you so much.
Agree.
You're welcome.
Any other board members have any comments or questions? We have anyone in the audience? No, Holly? Moderator, do we have anybody online that would like to make a comment on the the executive director's report?
This is the moderator. I do have a couple requests for public comment.
Okay.
First, I have Michelle Montserrat Ramos, and Michelle, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. We greatly appreciate Executive Director Calderon and her staff conducting outreach at the community's annual Latino Maternal Health Awareness Fair. Thank you for your interest in conducting public outreach. It is making a difference. Sunset review is very important to the public. We have focused on multiple sunset reviews with the medical board, and this will be the first year that we will be participating in sunset review with your board. As you know, the medical board requested that your board enter sunset review with them on the same year. The medical board requested to meet with me in person, which I did. I met with Dr. Yip, the board's new president, and their executive director. I also met regularly with your executive director. Yet the medical board has not yet met with your board regarding sunset review. At last week's meeting, they presented their recommendations for sunset review and voted for staff to continue researching and working on our legislative recommendations with no input from your board. We, the public, are caught in the middle. We were present at the medical board meeting last week, and we're here presenting to you today. I spoke to Dr. Yip about both boards meeting to discuss sunset review with us, and he was supportive. Board President Pines, we encourage you to contact President Dr. Yip to see how we can arrange for both boards to meet to discuss how we move forward for sunset review. In past sunset reviews with the medical board, we supported their fee increase. We advocated for them to obtain cost recovery, and we contributed greatly to their improved financial condition. We understand that this board, as well as the NBC, needs funding to meet your enforcement process expectations and to implement the recommendations we request. Therefore, we are willing to support actions you may consider to improve your financial condition. This issue is important to the public and requires us to work together. We are going to present our legislative recommendations to you. We're submitting a proposal to create an official appeal process for consumers. As you know, there is a reconsideration process for doctors. Doctors can also sue the board. All this done was with legal counsel representing physicians, yet families are left to struggle through the process alone and with little information to work with. We're requesting that you change the statute of limitations to a standard 7-year statute that will give consumers enough time to file an appeal and will allow staff enough time to review an appeal while also saving the board funding while avoiding forwarding last-minute cases to the AG's office. We're requesting inserting the opportunity to file an appeal in your closure letter when an email contact inserted. We're also requesting that staff provide a phone meeting with the family, providing them with reasons for why their complaint did not meet an extreme
15
departure
seconds.
or maybe one simple departure while protecting peer review. The aspect of the appeal process will provide closure for some families who may be willing to walk away when providing enough information for families to appeal with information. Our team is providing you with our other recommendations, provide you with our proposals and list as well. Thank you.
All right, this is the moderator. Next, I have Maria Ibarra Navarrete. And Maria, you'll be given 3 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I am Maria Ibarra Navarrete. I am from San Jose and a volunteer with Consumers Watchdog. Although we have participated in sunset reviews with the medical board, this is our first time participating in sunset review with this board. We look forward to the positive changes we can make and include in the sunset bill. As we did with the medical board in the past sunset reviews, we have legislative recommendations that we seek your support to include in the sunset bill. I work closely with Consumers Watchdog on legislative proposal to create an official appeal process for families. This proposal is personal for me, as I sought an appeal process with your board. And in the process of doing so, my statute of limitations ran out. As part of our consumer appeal process proposal, we are requesting that the statute of limitations change from a 3-year to a 7-year to a standard 7-year statute. The standard 7-year statute will give your board enough time to review and investigate our appeals and provide your board staff with enough time to review and investigate difficult cases without having to rush a case to the Attorney General's office, saving your board funding. We are requesting that your board provide notification in your closure letter that families have the right to appeal and provide an email address where families can email you with an interest to appeal. When staff receives the email, they contact the family to invite them to a phone meeting where board staff provides the family with information as to how their complaint did not meet an extreme departure from the standard of care without disclosing peer review. The family will either be satisfied that they have received information besides a form of letter that states insufficient evidence, or they will have real adequate information to pursue an appeal with your board. We feel that this is one way where we can make the enforcement process more equitable for families and seek your support. We are also requesting that you support our request to expand the special statute of limitations for minor children to include babies who were harmed or died due to pregnancy-related complications. We strongly urge that any physician who faces a second accusation against their license, especially one that involves patient harm or death, be mandated to take a competency exam as part of the disciplinary process. The first accusation may include serious issues such as patient harm, sexual misconduct, impairment, or fraud, while the second should directly be tied to the patient harm or death. This precaution is critical for protecting patient safety. Should the physician failed competency test, the board must enforce and cease practice until they demonstrate necessary competency to practice safely again by passing the exam.
15
Ensuring
seconds.
the thorough evaluation of medical professionals is essential for maintaining public trust and safety. Thank you.
All right, this is the moderator. Next, I have Lucas Evanson. And Lucas, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, my name is Lucas Evanson, speaking on behalf of the California Medical Association. With respect to the sunset review proposals, CMA opposes the recommendation to again seek a preponderance of the evidence standard for physician discipline. The policy reasoning in the Edinger case, which established this standard, is instructive here. The court, in concluding that the clear and convincing standard should apply, recognized that the disciplinary system for physicians exists to protect the public, not to punish the licensee, and that professional discipline can carry serious and lasting consequences, including the loss of the ability to practice one's professions. The clear and convincing standard should therefore not be viewed simply as an obstacle to enforcement, but as an important safeguard commensurate with the severity of those consequences. Making disciplinary cases easier, faster, or less expensive to pursue is not by itself sufficient justification for lowering that safeguard. CMA urges the board not to pursue the proposal to lower the evidentiary standard. Thank you.
All right, this is the moderator. Lastly, I have Kimberly Turbin. And Kimberly, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, can you guys hear me?
Yes, we can hear you.
Okay, hi, I'm Kimberly Turbin. I'm from Reseda and a volunteer with Consumer Watchdog. We're excited to participate in the Sunset Review with your board for the first time. As advocates representing the public, we strongly encourage you to consider several legislative recommendations that we believe should be included in your Sunset Review proposals. These changes can foster transparency and accountability, ultimately benefiting consumer protection. We urge you to extend the special statute of limitations for minor children to include infants who suffer harm or die as a result of pregnancy-related complications. This change is crucial to ensure that all vulnerable lives are protected and that justice can be pursued for families facing these tragic circumstances. We are requesting you to support our legislative proposal aimed at creating a formal appeal process for patients and their families. Currently, doctors have the right to request reconsideration after their case have been fully processed, and they can even sue the board for all of this done with the help of legal counsel. In contrast, families have no official avenue for appeal. We believe it is essential to establish equity and the enforcement process for everyone involved. Your support can make a meaningful difference in ensuring the process is more equitable for families. We're requesting that a physician with a second accusation against their license involving patient harm or death must undergo a competency exam as a part of their their disciplinary measures. Failing this exam should trigger an immediate cease practice order from the board, ensuring that the physician cannot practice until they demonstrate competence by passing this exam. This approach prioritizes patient safety and upholds the integrity of the medical practice. We request that any physician facing felony charges must promptly report these charges to the board. Additionally, once the board receives notification from the court, it is essential that the board post the details of these felony charges, along with any related license restrictions, on the physician's profile. Moreover, when a hospital takes disciplinary action, such as revoking a physician's hospital privileges, it is vital that this information is also included in the physician's profile. This transparency is crucial for public safety, as it indicates the hospital's loss of confidence in physicians' ability to treat patients safely. Providing this information to the public is not just important, it's necessary for ensuring informed choices for the public about healthcare. Thank you.
All right, this is the moderator. Appears there are no further requests for public comment at this time.
Great. Thank you all for your comments. We are now going to move to agenda item number 11, licensing program update from Machiko Chong, our licensing program manager.
Sorry. Okay. Good afternoon, Madam Board President Pines and members. I'm going to give a quick update for the licensing program for the last quarter of the 2025-26 fiscal year. Attachments 11A and 11B reflect the licensing population and application stats for the completed 25-26 fiscal year. Currently, there are 17,846 licensed osteopathic physicians and surgeons, 1,652 postgraduate training licensees, 1,621 fictitious name permits, and no temporary osteopathic physicians and surgeons licensure or PTO licenses. Since the 2024-25 fiscal year closure, the board experienced a 28% increase. A 28% increase in applications received and roughly an 18% increase overall since the 2023-24 fiscal year, which you'll see on attachment 11A. I did a compound annual growth average for you all so you could see the difference. Sorry. There are currently 221 pending initial applications, with 179 of those requesting expedited services for this for singular or multiple reasons. The application breakdown is as follows. For the application stats, we have 491 postgraduate training license applications in queue, and 221 osteopathic physicians and surgeon applications. Of those requesting expedite services, we have 4 for abortion services, 2 for refugees, asylees, or special immigrant visa holders, 167 requesting medically underserved expedite, 10 applications for military veterans, and 1 application for military spouses. In June, Dina Ruprecht, the board's PTL and F&P analyst, and I attended Arrowhead Regional Hospital's residency fair in Colton, California. The residents received clarification on many of the questions they had regarding requirements for licensure and the importance of establishing early communication with the board and staying in the know about the items that impact the osteopathic medical profession. Both the staff and residents were appreciative of our attendance, and we look forward to our continued work with the program. We also were able to unveil our new document upload portal, which a lot of the residency programs are still getting used to. And we're finding that it's a lot more effective than sending documents in via email. And so they have been utilizing that a lot more. In July, the CME Compliance Unit, comprised of both Jaime and David, initiated the first of our CME audits via a randomly selected list generated by the Breeze database. Licensees were contacted via written correspondence regarding their need to provide accurate documentation for the CME cycle indicated on the request letter. And for those individuals who are found to be out of compliance with the mandated CME requirement, enforcement cases will be initiated by licensing staff with all additional proceedings, if necessary, being handled within the licensing unit. And for those licensees that are being generated by the system, it's the month prior to for them. So the report is generated on the 15th of every month. So anyone who renewed at this point, July, that had an expiration date of July 31st, they were pulled and they have to provide us with documentation attesting to the fact that they've actually complied with the CME program. So that will happen on the 15th of every month moving forward. That concludes my report, and I will field any questions from the board members or public.
On the audits, what's the percentage of people who are not complying?
Actually, we have none to date. We don't have anybody that's out of compliance, correct?
Oh, great.
I'm glad you mentioned. I looked over to you, Ms. Pines, because I knew you were going to ask that question, and I was actually going to provide a little bit more to Machiko's report in that area. We're finding that our physicians are extremely educated on what they need to submit, and I want to say that it's because of the many years that they had to submit documentation, and we were doing 100% auditing, that Jaime and David really educated them over the last decade or so of how long we've been doing that, actually since an initiation, right? So they're extremely informed of their requirements. They are completely compliant. We did initiate 2 cases out of the audit, but it was because they didn't understand the question. So they answered no to meeting the requirement, but when we contacted them and got information, a response back from the 2 doctors, they said that they accidentally marked the wrong box, and they submitted their documentation and it was completely accounted for. So we have yet to do a citation or a failure. We have yet to do an ignored audit. So they're complying, they're getting responses submitted. So we ruled this out 3 months ago, Machiko? 2-3 months ago. And
2, we're on our second audit right
2.
now.
So it did take us a little bit of a little time to get it up and going with our brace system, and the interface, mainly to get that report generated, was like the last missing piece. But yes, as of 2 months ago, we're fully implemented, and we couldn't be happier with the response that we got. Just as a reminder, our rate packet called out for a 10% of our population. So that's what we're starting with. And later on, if the board wishes to lower that based on our response, that everyone is responding and showing complete proof, we can lower the 10% of population if the board wishes. But the rate packet does call for a 10% of our entire population. Other boards, just to give you an idea, are at a 5% right now. So they've rolled out potentially at higher percentage rates, and they've managed to lower it down to a 5% of their population based on the responses that they're getting. We're kind of heading that way with not much of an issue. Mhm.
Another question I have is just around the increase overall in the applications that's being received. How is the staff handling? It's a pretty significant increase, 18% in areas, 55% in some areas, overall almost 30%.
As of right now, with the 2 analysts that I do have handling the full unrestricted and the one with the F&Ps and PTLs, they are able to carry the workload, especially now that we're electronic as opposed to manual. So that's taken a lot of the work off of their plate. But at some point, we will have to entertain the idea of probably implementing more staff to assist breaking down the alpha a little more, as opposed to just halfway split down the center, maybe incorporating another analyst, maybe.
Okay. All right. Thanks. Do any board members have any questions, comments?
Ms. Chong and Ms. Calderon, is there any more context you can lend as to why we're seeing such a significant, or at least certainly noteworthy, increase year over year?
It's California. Everyone wants to come here. No, but that really is a thing. California has always been on the forefront. So it's not unexpected that the rates have increased the way they have. I think also the implementation of the PTO license a few years back has driven a lot of those residents to want to stay in California. The oversight of the PTL. So that's all I can say is, everyone wants to come here. And, with the addition of the new school, CHSU down in Clovis, and us having 3 campuses here in California, I think that's helped as well.
I appreciate that, Ms. Chong. I was very curious about this last year over year, since there seems to be.
I know, a lot. It's increased a lot.
Thank you.
Ms. Pines, if I can add to the portal a little bit more to explain the portal. The portal that we, sorry, portal. What we created is a interface on our website. As you recall, several years ago, Montreco was asking for us to obtain a Veridoc system like the one medical board has. And the alternative that we have is now on our website. There is a document upload platform that was created. There's a link on our homepage on the top header, and it's specified document upload, and it's not just used for licensing purpose. I want to also reiterate that we created 4 forms, and we can create as many as we would like. They're called forms, but it's a link to the different types of resources that we're trying to use this portal for. So there's one for applicants so that their postgraduate training programs can upload documents, their schools, and it's verified. We have an attestation that the person who's uploading the document has to submit it. I want to also say that for the enforcement side, this is also something that we created. Once we knew what it was capable of doing for licensing, we opened the door for the enforcement program to also take advantage of this. So when we're requesting medical releases from our consumers, instead of having them send back their releases, and Macha goes, thank you. She's gonna kind of give you a visual effect of what I'm talking about here. It would allow a consumer to upload their releases instead of mailing them back to the board. So it's less costly for the consumer to have to, send it through regular USPS mail. It actually, at the moment they hit submit, our staff gets a notification on our email that there's been a new submission and for the specific license, the specific program. So this is linked to staff all over the board. If it was a submission that was submitted for the enforcement program, it would come to Christie staff. If it was submitted for licensing, it would be directed to Machago staff. And for Machago, there's the applications one, and then there's also the CME audit process. So they can upload their records here. It avoids lag in time frames when we're waiting for the mail to come in through USPS. It saves money for our consumers and our programs as well. So the exchange of information is secured and on time, like right at the moment.
Right. Okay, thank you, Machiko. Are there any members? My mic is on. Yeah.
Sorry.
You didn't hear? You can hear me? Oh, okay. Can you hear me now? That's okay. Um, going to members of the public in the room. Do you have any comments?
Holly McChris, Executive Director, Osteopathic Physicians and Surgeons of California. I just want to comment on the question about why do we think there's so many that come here. I think California is a special state. The fact that we have a pretty good separation of corporate medicine, the business of medicine, and the practice of medicine, that our physicians are actually allowed to practice the medicine that they went to school for. And get to treat the patients the way that they're educated to do. The next state that's closest to us, if those of you don't know, is Florida, and they have 13,000. So for us to be that far ahead, I truly believe it's because California allows our medical professionals to be the outstanding physicians that they are and provide the care that's necessary. Just want to share that.
Thank you. Are there, moderator, is there anyone requesting comments online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, next up is agenda item number 12, our enforcement programs update from Christy Memento, I always say your last name wrong. The Board Enforcement Program Manager. Thank you.
Okay. Good afternoon, Madam President, Denise Pines, board members, Christy Livramento, Enforcement Program Manager. This report provides an overview of the enforcement program's activities and performance for fiscal year 25-26 with comparative data from fiscal year 24-25. Please refer to attachment 12A for statistical comparisons. Despite the temporary absence of one of our enforcement analysts who has been on leave since July of 2025, our enforcement program has upheld its commitment to operational excellence. As of the date of this briefing, the analyst has not yet returned. To ensure uninterrupted operations, we have posted a limited term analyst 2 position to provide coverage in her absence. The application period for this role has closed and interviews will be conducted soon. We've also announced the limited term office technician position to support the enforcement program with complaint intake and a range of administrative duties. Interviews for that position were conducted last week. Key activities and statistics for quarter 4 for fiscal year 25-26. For complainant interviews, 20 complainant interviews were offered in quarter 4. 13 have been completed. 6 are pending, and we've had 1 case where we've received no response to our interview request. 805 reports received. During quarter 4, we received 18 total 805 reports. For educational letters that have been issued for minor violations such as record keeping or communication issues that do not warrant an administrative citation or disciplinary action, a total of 47 educational letters were issued during quarter 4. And as Erica explained, closing/educational letters have been updated to inform the consumer that although action is not taken, that the subject has been educated on the situation. Overall performance measures. Performance measure 1, during the reporting period, the program received a total of 1,340 consumer complaints and 40 notices regarding arrest or convictions from DOJ, resulting in a total of 1,380 cases for the fiscal year. This figure reflects a 25% increase compared to the previous fiscal year's total of 1,035 cases. As previously reported, this growth is primarily attributed to expanded outreach initiatives, a rising number of licensees, and the board's implementation of annual F&P audits as well as CME audits. Performance measure 2 is the measure for complaint initiation and acknowledgement. The goal is 10 days. Year to date, we are at 5 days and meeting that expectation. Performance measure 3 is the investigation and enforcement completion of cases that are not referred to the AG's office. The target for completing investigations not referred to the AG's office is 360 days. The current year-to-date average is 213 days, meeting this performance measure. Fluctuations in this metric are influenced by the inclusion of both desk and formal investigations, with complex cases potentially skewing the average. Performance measure number 4 is the investigation and enforcement completion of cases that are referred to the AG's office. The target for performance measure number 4 is 540 days. Year to date, the average is 777 days, which is a decrease from 955 days from the last fiscal year. This measure is also influenced by timelines beyond the board's control, including those of the Attorney General's office, respondents' legal counsels, and the Office of Administrative Hearings. Case inventory. Overall pending cases, the board currently has 827 pending enforcement cases, including 147 cases pending formal investigations and 22 pending formal discipline. Formal investigations at the conclusion of last fiscal year, 81 cases were pending formal investigations compared to 147 at the end of this fiscal year, which is nearly doubled the amount from last year. The average caseload per analyst is currently at 276 amongst the 3 analysts, with the 1 enforcement analyst being out on leave. Formal discipline actions year to date, we've filed 15 accusations, 2 accusations and petitions to revoke probation, issued 4 public letters of reprimand, placed 4 licensees on probation, accepted 4 license surrenders, ordered 3 revocations, issued 1 interim suspension order, issued 1 automatic suspension order, and 14 administrative citations have been issued. No action is requested by board members.
Okay, thank you. So if you were to have someone get really sick or take time off, you guys would be in trouble.
Yes, ma'am.
So
The answer to that, Ms. Pines, is that Christy, previously being an enforcement analyst, would have to step in and carry her own caseload. Unfortunately, I would love to help, but there is a separation of duties when it comes to me handling enforcement cases. But Christy is a fully capable analyst at one point, having 11 years of experience prior to taking on this role. So she has stepped in to support the unit. We never want to take support from other programs within the board because we can see that it could be detrimental. This board previously supported the licensing program when we didn't have our applications online, and that was what caused the huge backup in enforcement matters. Going back to the statistics, I do want to highlight that you can see that there's a big amount now going to the field that's pending with the field. A lot of those initiatives, came out of the enforcement, let's say the medical consultant program that we created on our own, which is essentially being handled by Christy herself. Typically, on a bigger scale board like the medical board, they have staff that handle bringing on experts, helping with the billing of experts. And Christy is handling that role in addition to reviewing every consumer complaint that gets analyzed by one of the analysts for closure, for referral to the field. So she, at this moment, is essentially every single case that goes through an analyst is going through her hands too. So if you can imagine the amount of workload in forwarding the case, assigning it to an analyst, and then having to review every single closure. So does she have time? No. So in the meantime, we are using our blanket authority to bring in staff, which then goes into our budget. We're pulling out of our budget to bring these additional support staff. One of the hopes in, raising our fees as Christy's walking in with our reg packet is to bring a better condition in our budget so that we can then look into bringing more support staff. For in this moment, both programs, we're growing on both sides, licensing and enforcement. So I would say that we're barely above water, both in the enforcement side and soon to be licensing as well.
Yeah, I think it's obvious. Do we have any board members with any comments or questions?
I do.
Yeah.
Brett Lockman. So for performance measure 4, it seems like the AG's office is a huge bottleneck. They're the top law enforcement word in the state. So what's their issue? They're supposed to be all about compliance and following the rules, but they seem themselves to be kind of falling through the cracks. How do they justify that? If we all have to as the board, try to ensure our enforcement of physician rules and whatnot, how is it that?
So after the accusation is filed, there's a lot of outlying factors, including getting hearings scheduled with the Office of Administrative Hearing and communication between the Attorney General's office and the respondent's attorney regarding settlement, regarding hearing dates. So that can take up a lot of time for our cases as well.
Machika, will you bring up the stats? I do want to point out that in that area, we did see a decrease. The first page 2, yeah.
I do see the stats.
Okay.
I'm wondering, is the 540-day goal just completely unrealistic, and is it ever going to be met? Because if we set a goal, or if they're setting a goal, and then they say, well, we can never meet our goal because there's the attorney back and forth, and there's limited funds and limited this and too much of this. At some point, do you simply reset the curve to have an attainable goal? Or at what point do you just have to look in the mirror and say, wow, we ourselves need to get our act together and meet our goals in life?
So our goal in general is to file that accusation before our statute of limitations goes away. That's when we lose a case, and unfortunately, we have to close it without taking action. We are not at this moment losing cases that have been under our control due to statute issues. So that's a correction. In terms of I wouldn't say a correction, what we have been working extremely hard on. The performance measures are set there to kind of give ourselves target dates. They are not truly a measure of performance for each of the entities involved. An investigation, depending on the evidence and what we have and the collaboration of witnesses, can be handled in 3 months. And then there are some that have to take longer. And it's a variation of different things. One of the things, Dr. Lockman, to kind of help answer the question, we are competing with other healing our boards. So the Attorney General represents a lot of us, not just the Osteopathic Medical Board. We do have our health and quality units, both for D of I and the medical board realm, where we're in partnership with the Medical Board of California, the PA, so Physician Assistant Board, Podiatry, and obviously the medical board, podiatry, PA, us, and osteo, and they handle cases based on urgency amongst their clients, whether there's a statute issue or not. So we are, in the same bucket as those healing our boards, and they monitor us closely. I can tell you that the AG's office has filed an accusation literally overnight for us if it's needed. So we have a DAG liaison where we can draw, communication and attention to matters that are coming their way with short statute of limitations. But it is something that we work in conjunction with D of I and the AG's office to see how we can help reduce timelines.
Sure. My question or critique is not so much, it's not with the OMBC and our process here. It sounds like, maybe I misunderstood, a lot of the work that Christy and enforcement analysis is doing is maybe being sent to the AG's office, where it then gets bottlenecked. And these are, am I misunderstanding that? Or, and if not, and they understand that we have a statute, but they're, whatever, not necessarily there, but the bureaucracy, the machine turning is turning so slowly that cases may fall through the cracks because they outlive the statute of limitations before enforcement happens, then that's not serving public safety. And so it begs the question, where does the Attorney General's office have to spin that wheel faster, and how do we crank that wheel faster?
We're not experiencing any concerns. When we transmit a case within 5 days, we get a letter of acceptance or rejection. And we're seeing accusations getting filed within 2 to 3 months from transmittal. So we're truly not seeing an issue, Dr. Lockman. When it comes, once the accusation gets filed, our statute stops. And we can take, a couple of months before we enter into stipulation agreements, discussions, or we get them calendared. We're not really seeing an issue.
So when the accusation gets accepted, so to speak, does it start tolling at that point? We've met our goal? Maybe some of the.
When it's filed.
What's that?
When it's filed.
Okay, so this 540-day goal, but the year-to-date average being 777 days, that's not risking those cases being lost to the statute of limitations.
That's taking the total amount from beginning, from initiation, all the way to the Attorney General's office. So maybe that's where the miscommunication is, that it's the 700 is taken into account all of the desk investigation, plus DFI, plus the Attorney General.
Okay.
Is that?
Yes, that.
Okay.
I thought maybe nothing was happening for 777
No,
days.
sorry.
And we're
Yes.
losing, okay,
Yes.
I stand corrected.
Yeah.
So, Ms. Calderon, it's been a few meetings now. We've identified this need for additional resources. And we've also identified increasing fees as a potential avenue to meet that need that could be devoted to enforcement. So at what point would this be an appropriate time to discuss that, especially since we have not increased fees, to my understanding, on this board for more than a decade plus, to even keep with inflationary measures?
Thank you. Good question. We were overdue for a fee increase, I would say, for quite some time, right? One of the factors that I keep on mentioning is the overexpending in the line item of enforcement we send to the field, the more expenses we have, and the more cases we send to the Attorney General, the more expenses we have. So that this is, unfortunately, we're fixing our board in many areas. Our budget needs to be aligned with conducting business. So that's number one. And in order to do that, we do have to move all the moving parts. In this instance, bringing in our fees and to our caps is step one. Potentially going into sunset, asking for an additional fee increase is another, or extending our caps to a higher level so that we can, for the next 4 years, take into account how much we're spending and how much we need to bring in that support. As you know, we don't, and I think it's been clarified a couple of times today, that we don't get funding outside of what we're bringing in as revenue. So I don't project us jumping on getting positions quickly after. We have to bring our budget to a good stand. I would say the months in reserves that is appropriate to be in is 8 to 10 months to be okay. And we need to work on that first before we introduce bringing on staffing. Of course, one other important thing to keep in mind is that new legislation that's imposed on our board would require us to bring in more staff as well. So in addition to our own need because of our increases in both licensing and enforcement, we have to keep in mind that new legislation can introduce more workload. So that's a factor. Going into sunset, we have to keep that in mind as well, that if there is more workload that's going to be added, that's something that we need to also consider.
So my understanding from you in your commentary is not only do we have a need at present, but there is many credible circumstances and factors that we anticipate are going to increase that need. Is that correct?
That is correct in the upcoming years. As we see our licensee population increase, we're going to see additional consumer complaints. As we continue with outreach efforts, we're going to see an additional increase in consumer complaints. So both forces kind of drive from each other. An increase in licensing population equates to more complaints, which equates to expenses on the enforcement side. So as we grow, our staff needs to grow. We physically at our board, we don't have any more room for anyone. So there's going to be a need to even move to a different office to accommodate staffing, especially with us coming back, the 4 years. So is it at a present time, do we have a lot to work on? Yes. If I can put a goal in mind is, getting our reg packet approved to bring in the revenue that we need at this moment, working with the executive committee to bring proposals to sunset, and then really working on growing our staff because we really don't have a wiggle room. Denise's question, if any of us get sick, what happens? It could be detrimental to our board on both areas.
But I do understand that there's an avenue to be able to discuss this topic and potentially be able, as a board, to make a decision with respect to increasing fees even before sunset. That sunset, including it in that package, would be one avenue, but we could move on that before that as a separate and distinct avenue. Is that correct?
That is correct. So agenda item 14 is to move our regulatory packet that we have right now. That's going to increase our revenue a certain percentage to start off with. We need to be able to have our fees at the caps statutorily so that we can introduce and sunset a potential increase as well for our caps to allow growth within the next 4 years that we are definitely going to experience.
Okay, do we have any other comments by board members before I move to the audience? Okay. Holly, you say no? No, okay. Moderator, do we have any comments online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Thank you, Christy, and thank you for the outstanding job and the extra work that you're doing. We
Thank you.
appreciate it. Next up is agenda item 13, a probation program updates from Ralph Correa, the board's probation monitor. Good afternoon.
All right. Can you hear me? All right. Good afternoon, folks. Just want to give a special thanks to my Lord and Savior, Jesus Christ. Thank you very much for allowing me to be here today. I want to start off by telling you guys, obviously, my name is Ralph Correa. I am the probation monitor assigned to the Osteopathic Medical Board of California. For updates today, we got a total of 36 licensees on probation. I did go up, I believe, 2. A couple did fall off for the past couple months. We do have 5 licensees that are pulling out of state. In other words, they reside outside. They are not practicing medicine here in California. And of course, they are not receiving credit for the completion of their probationary time. 31 probationers the cases are actively being monitored, and are obviously currently practicing medicine here in California and seeing patients in California. As far as public reprimands go, we do have 2 physicians that have received public letters of reprimand and are being monitored for their regular case activity based on completion of their courses and or fines that they are going to be required to pay. As far as review of their cases, quarterly reviews, I do conduct those on a regular basis. Those are being done both either in person, on the telephone, or a Zoom type focus. And I go over with each and every probationer regarding their terms and conditions to make sure that they are following them, make sure all documents are processed, analyzed, and then of course I generate a report that actually dictates exactly what was talked about from myself and reminding them of what they're required to do, what I received, what I didn't receive, and so forth, okay? Regarding the probation issues, we did have, at the time, there was one physician, there was actually 2 physicians who had ceased practice orders. One physician actually decided to surrender their license. And now we still have one physician who remains on a cease practice order and will still remain on that cease practice order until the course program is completed. And when I say completed, it has to be successfully completed, not just said that they did it. And of course, if that physician does complete the next round of course or program, then the cease practice order will either be released or that cease practice order will remain in effect for that time. Okay? That's all I have. Does anybody have any questions or concerns?
Board members, any comments or questions for Ralph? No? Any members of the audience have any questions? Moderator, is there anyone online who would like to make a comment?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Thank you, Ralph. It's gonna go long. Yeah. Okay. Okay, we're gonna take a 5-minute break. Okay, we are going to do a roll call. Machiko?
Nagin Maragabi. Dr.
Present.
Lockman.
Present.
Dr. Patel.
Here.
Madam President Pines.
Here.
John Cummins.
Here.
Gora Damian. Dr. Kazi.
Here.
Dr. Swain.
Here.
Dr. Walsh. A quorum has been established.
Great. We are now going to move to agenda item number 14, discussion and possible action on rulemaking to amend sections 1630, 1636, 1646, 1647, 1656, 1658, and 1690, and to adopt section 1648 in the division 16 of Title 16 of the California Code of Regulations. We are joined by Terry Thorfinson, Legislative and Regulatory Specialist, and Katie Christie, I'm sorry, Shields, Attorney for Legal Affairs Division Regulations Unit at DCA. So first is, this is a consideration of public comments received during the public comment period and proposed responses thereto. So who's going to discuss Terry, you're going to discuss what has come in? Okay.
Yes. Thank you, Madam President and board members. I just wanted to give everybody a little kind of overview of the structure of this memo. So you understand there's bookmarks on the right side for documents. is the memo, and embedded in the memo are the sections that we're proposing to modify the text, and they're highlighted in yellow inside the memo. And then the attachments are other language that the board has actually approved in past meetings, but that would be where those 1 through 5 is proposed language. Attachment 6 are the workload charts and that go with the fee proposals for each of the license and fee types that we are proposing to change to bring it up to the statutory cap. And then, so with that, this has 2 parts to this agenda item. The first part is reviewing the public comments received. This particular, the board approved this last November. It was approved by the Office of Administrative Law to go out to public comment. That public comment ended in July 13th, 2026. And as a result, the comments that we received, the board were presenting to the board to consider. And also included in those are staff recommendations and responses to those particular comments that were in the memo. And then the second part, so that was part A, and then the second part is B, and that is considering some modified language, technical in nature. And to put in perspective, the board has reviewed and approved the substantive part of this reg package at their last meeting in November. So this proposal for modified language that is part of the B of the agenda item is just technical changes, which we'll go over. So Christy, do you want to add anything to that introductory? Okay. So the comments I'm going to for brevity of time, I'm going to highlight some themes, namely that several of the comments raised cost as an issue and the fee amount as issues. And the board's response is pretty uniform, which is if you look at attachment 6 that has each of the workload charts and cost to the board by fee, you will see that the fees are justified both in terms of workload and the cost to the board. And so this, as Erica had pointed out earlier, is step 1 in the fee increase. This is to just bring a sort of what I would consider modest changes to the fee levels to the statutory cap. What does the statutory cap mean? Is by statute, the board is only authorized to do things per authorization and from the statute, and that's true for fees. So fees are authorized and a cap is put in our statute that says we cannot charge per our regulation any higher than those fees. So this consideration today is just bringing the fees to the cap that's in our current statute, and the justification workload-wise is in attachment 6. And I think I'm going to leave the rest of the board responses to you. I think you've probably all read them. And the staff recommendation is to reject all comments, make no modifications as a result of comments received by the public, and to proceed with approving the language that you have previously approved in November of 2025, and that would be a motion A to consider.
Yes, I do actually want to add something. So if you look at page 21, as Ms. Thorfinson mentioned, this is a 2-part item. The first part is to review the comments that came in during the public comment period and see how the staff are recommending you respond to each of them. As you've seen, mainly the complaints which are not surprising, were about the fee increases. The amount of money we were proposing to charge for the retired license status application, that was one. And also obviously the petition for modification of penalty application fee and the adjudication fees. There were a lot of adverse comments about that and why the board was requiring people to front those costs and asking for other adjustments or waivers to those fee amounts. So as Ms. Thorfinson indicated, the recommendations were to reject that. those comments. As we've discussed, the board has got a pending structural imbalance issue, which could result in the board running out of money. So it's really incumbent upon the board to do as much cost containment as possible. And so all the items that discussed opposition to increasing fees or adding fees, we're proposing to reject because you need to recover as much money as you possibly can within your authority to stay, in the black, if you will. So the motions and the action requested start on page 21 for the first item. The second item will go over the modified text if there are no concerns with the requested action in the first part, which is to direct staff to proceed as recommended to reject the adverse comments as specified and provide the responses to all comments as indicated in the staff recommended responses as set forth in the meeting materials. That would be the motion you would do if you have no concerns with our responses. If you do have concerns, please advise. Thank you.
So can I get a motion on A as the staff has directed?
This is Matthew Swain. I move that we accept the recommended responses, the recommended staff responses to the public comment.
Can I get a second?
And then Walchuk second.
Great. Board members, do we want a discussion on this? Does anybody have any comments? Members in the audience? No. Moderator, is there anyone on the line who would like to make a comment?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. And it looks like we do have a request from Lucas Evenson. Lucas, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, thank you. First, just to clarify, is this public comment on agenda item 14A or 14 as a whole?
14A.
Okay, thank you. So hello, my name is Lucas Evanson, speaking on behalf of the California Medical Association. CMA appreciates the board and staff's review of our comments. We recognize the board's desire to recover reasonable costs associated with petitions for penalty relief. Our concern here is not with cost recovery itself, but with the board's decision to require petitioners to pay the full adjudication fee upfront without the same flexibility recently adopted by the Medical Board of California. The Medical Board of California's regulations provide a more balanced approach. They allow a lower initial filing fee while preserving the board's ability to recover reasonable costs after the petition is heard. Importantly, they also allow consideration of the petitioner's ability to pay, the reasonableness of the fee, and whether a payment plan reduction or waiver is appropriate. By contrast, the OMBC's proposal would require osteopathic physicians to pay a substantially higher upfront amount before they can meaningfully access the petition process and without the options of a payment plan reduction or waiver. That creates an inequitable result. A DO seeking penalty relief before the OMBC would face a more punitive and less flexible process than an MD seeking the same type of penalty relief process before the MBC. We do not believe osteopathic physicians should be placed at a disadvantage simply because they are licensed by a different physician licensing board. For that reason, CMA respectfully asks that the board either withdraw the motion or vote no on this motion and instead use motion B under section A in the meeting materials to revise the proposed response to CMA's comments to reflect that the board accepts our recommendation to align its petition fee approach with the MBC's regulations. Thank you.
Thank you.
All right, this is the moderator. Appears there are no further requests for public comment at this time.
Great. We have a motion and a second. Can we get a roll call?
Dr. Kazi. Dr. Swain.
Yes.
Madam President Pines.
Yes.
Dr. Patel. Nagin Maragabi.
Aye.
Dr. Lockman. John Cummins.
Aye.
Dr. Walsh.
Aye.
Gore Damian. Motion carries.
Great. Okay.
Okay. I'm going to move on to Part B of this agenda item. And this is a discussion and possible action on proposed modified text, which is a technical change. I will say the fact that if you recall, we voted on this same package more than once because we found things that we need to add. In this case, the technical change is adding language that would be on the applications for the renewal and both active and inactive that would be what requirement for information to be provided to the board would be needed. And the way that we are writing our code is so that the requirements are fully that would normally be in the applications are in the code. That gives greater flexibility in the future to changing applications as long as they meet our code language, and we've forgotten what would be that requirement. And so that is for if somebody answered yes to the question. And I'll leave Christy, let Christy explain further.
So on your current active or inactive renewal application, the question that is asked is whether since their last renewal, they've had a conviction or any disciplinary action against any license they hold. Inadvertently, in this draft that we circulated to the public, we forgot to add, if they answered yes, that we wanted certain detail to be disclosed, like which jurisdiction, what the violations were. And so we're adding that in now to just make sure that the staff gets as much information as possible when they're investigating whether there could be a potential violation of your act, rather than making the staff, actually call the person and get the detail, actually front loading that information and make sure that information's provided with the answer if they answer yes to either of those questions, either for an active or an inactive renewal. So that's the big substantive. Those are the big substantive changes that we were going to be adding, just that further clarification. And then there were some errors that we were going to correct, that a statutory section was inadvertently, a regulatory section that required, this is the existing regulation, that the petition be accompanied by 2 verified recommendations from physicians and surgeons licensed by the board. Well, when that regulation was adopted, that was the law, but the law has changed so that it can be a physician recommendation from anyone licensed in any jurisdiction in the United States. So that inconsistency would be caught by the Office of Administrative Law. So we struck that section so that it could be consistent with Section 2307, which now allows any recommendation from any physician in the United States. So that was a cleanup. In addition, there were in another package I was working on for another client, the Office of Administrative Law wanted just to add more clarifying language about who has the authority to reject fingerprint cards and live scan submissions, which is obviously the Department of Justice. We thought that was self-evident, but OAL thought we needed to put that kind of detail in the regulations. So I just added that to your proposal so we could not have that hold up anything once it's going through review. So just those kind of minor cleanup changes in those 2 issues with the renewal questions that I mentioned that we're asking for your authority to proceed with another 15-day notice to make those corrections before we wrap up this package, hopefully. That's the goal. And so the motion language for that would be on page 22, right?
Yeah, 20.
It's 32.
32, sorry.
32.
I get
Mhm.
numbers mixed up. 32. So those motions would, if you have no changes, it would be the first motion on page 32.
Okay, I see the motion. Motion B, language. Can everyone see that? Or do you guys need me to read it?
And just to add, I've included the sections that we're changing.
Okay,
And
motion.
they're highlighted. If you scroll down on your way to page 32 and that motion, and those motions, is that the changes are highlighted in yellow.
Okay,
Christie
so
summarized them, but to see the actual language, we have
Mhm.
them highlighted.
so motion A, language.
And motion A is no changes and approving these, modifying has proposed these technical changes.
Okay.
An unfun motion, but it is the language the Office of Administrative Law requires us to use to prove you delegated the authority to move forward with this package and to wrap up the rulemaking. So I
Okay.
can read it if you don't want to.
Okay, read it.
Depends on which you want to go with, so I don't know.
Okay, you read it.
Which one?
Motion A would
Motion
be-
A.
Okay.
Of no changes.
So the proposed motion would be to approve the proposed modified text in attachments 1 through 5 and direct staff to take all steps necessary to complete the rulemaking process, including sending out the modified text and notice for an additional 15-day comment period. If after the 15-day public comment period, no adverse comments are received, authorize the executive director to make any non-substantive changes to the proposed regulations and the rulemaking documents and adopt the proposed text included in 16 CCR sections 1630, 1636, 1646, 1647, 1656, 1658, and 1690 in Section 1648 in Division 16 of Title 16 of the California Code of Regulations as provided in the noticed modified text in attachments 1 through 5.
Can I get a motion?
I so move. John Cummins.
Okay, second? Can I get a second?
Second that.
Okay, great. All right. Are there any comments by board members? Any comments by members in the room? Moderator, is there anyone online that would like to make a comment?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. And it looks like we do have a request from Lucas Evenson. And Lucas, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello again, my name is Lucas Evanson, speaking on behalf of the California Medical Association. CMA appreciates the opportunity to comment on the proposed modified text. I would just like to briefly reiterate our concern regarding the petition fee provisions. If this motion is approved, the proposed text will continue to require osteopathic physicians seeking penalty relief to pay the full adjudication fee upfront, while the Medical Board of California has adopted a more flexible process for similarly situated allopathic physicians. Again, this issue is not whether or not the board may recover reasonable costs. The issue is whether the board should do so in a manner that creates a more punitive process for DOs than the process available to MDs under the MBC. The MBC model demonstrates that a physician licensing board can protect its fiscal interests while still preserving meaningful access to the petition process and allowing consideration of a petitioner's ability to pay. CMA therefore respectfully asks that the board either withdraw the motion or vote no on this motion and instead use motion B under section B of the meeting materials to accept CMA's comments and direct staff to revise the modified text to align the OMBC's petition fee regulations with the MBC's approach. Thank you.
Thank you. Thank you. Machiko, can we do the roll call?
Dr. Kazi,
Aye.
Dr. Swain,
Aye.
Madam President Pines,
Aye.
Dr. Patel, Nagin Maragabi,
Aye.
Dr. Lockman,
Aye.
John Cummins,
Aye.
Dr. Walsh,
Aye.
Gore Damian. Motion carries.
Madam Chair, may I just, at a parting comment, thank you for your presentations. The issue of collection of the fee can potentially be managed and handled separately by staff if it requires the payment plan or if there's a petition as such to if there's a need for a payment plan. That could be a distinct process. It doesn't have to be specified in this broad document. So something to consider, and maybe staff can come back to us and educate us on what that process could look like in the future.
That could be something for a future agenda item, but the current proposal is that they have to pay the fees up front, and then if the fees end up being lower than what is typically your fee costs, then there would be a refund to that individual. The whole idea is that we're shifting the cost recovery requirements to the person who's using the service so that the board and compliant licensees are not essentially subsidizing these petitions, which you've been doing for 46 years. So for 46 years, no one's had to pay. And so those costs have been distributed across the entire licensing population. So people that have never had discipline, that don't have probation, that don't need to petition, are paying for those that do. And so if we're going to be going forward and asking people to accept a fee increase, we have to also then show them that we're using all of our strategies to lower their costs as well. I think that was a fair ask. Some of the commenters said, what are you doing to control your costs? Well, this is an example where we're pushing the costs back onto the people that are using the service. So I think if you want to consider a payment plan option, I would say that would be a future regulatory proposal. Now, remember, regulations are not fixed in stone. If you send this out and it doesn't seem to be working for you and you want to make changes, you're free to bring this back and make changes. But I think that going out of the gate, going into sunset when you're in structural imbalance and you're having funding issues, you're in a stronger position coming in with, we've done everything we can to control our costs, and now we need some additional help from you, legislature. So you're in a stronger position legally.
Thank you, Christy, for explaining
You're welcome.
a little bit further.
I think I would also add that our proposal is different in the sense that we're offering an accounting, which is full transparency, which the Med Board is not, and a refund option, which the Med Board is not. And in the context of not knowing, are we setting the fee at the right amount? Well, based on our attachment 6, we came up with what our costs are. And so we are initially out the gate setting it at what our costs are. The idea of setting it lower would jeopardize the board's fiscal picture going forward, and it would potentially allow a subsidization of the fees. And so it's still a cost to the board, and that's what I want. That's what ours was trying to provide, flexibility and transparency, but also having the board have reimbursement for what the costs are, which has not been the case until now. So just to give you our idea, our approach is different, and we think it's fairer in that sense. But as Christy pointed out, if through experience, if the board wants to, revisit it, we're always free to do that at future board meetings.
One more thing to add, and you also have to look at your budget versus theirs. I mean, maybe they aren't as hard pressed as you are, and they can potentially absorb any fees that are waived.
They've already
ALJ
had fee increases.
Right, because the Attorney General's office, if an ALJ says, I don't think these are fair, and then the board discounts it, you still have to pay it. We have no recourse from the Attorney General's office to say, we're not going to pay your bill. We have to pay it by law. They take it right out of your account, actually. They don't even ask. They just take it right out of your account. It's just deducted. So the problem with that approach is that we're having to make sure that you can absorb those kind of waivers and payment plans or structural changes that would allow deferred payments or deductions. You'd have to see. Right now, we're not seeing that you can do that. That's why we're coming at this a more clean approach where you're not going to have to worry about chasing money down. You're not going to have to worry about whether you shouldn't have deducted that amount because now you can't pay for your next enforcement case, or you can't hire another analyst to fill a position. So, while I understand the concerns, I mean, this policy was enacted by the legislature. They were made fully aware of all the costs involved with petitions. That's how the medical board got the statutory change. They actually gave them the data on how much it costs. And they said, okay, let's shift that to the petitioners. We'll shift that cost to them. That was a state policy decision. You're simply implementing the policy you were given. You didn't make that policy, that decision, the state did. And so you're just implementing that. But again, as we discussed, look at how it's working in real time, see if there's concerns. And then if you have the money and you can afford it, you can think about making some kind of switches and changes at a future meeting. That's my recommendation anyway.
Okay. So are we now moving to Agenda item 15? No. Okay.
Yes.
Yeah, yeah.
You did. Voted, yes, yes, we did.
Yes, you did. We did.
We did. We had discussion and we just added.
Yeah.
We're good.
All right. Terry, you want to?
Okay, so I'm going to move to, thank you, Christy. It is always a pleasure working with Christy. She has incredible expertise, and it's always a pleasure to have kind of, this partner in explaining some of the intricacies. No one person can do it all, so it's good that we have her. Thank you.
Thank you.
Turning to agenda item 15, which is the update. Again, in the interest of time, I'm just going to say that we basically have this package, which we've approved language, which then we are going to go out to public comment for 15 days, and then we're going to package up. Well, no, we have to then bring the comments back to the board to consider.
Yeah, let's hope we don't get any comments. That would be nice.
Yeah,
If we can
yeah.
get no comments, then it'll just move through the process and get filed.
So it's possible.
Can I ask a question?
Yes.
What if the comments are the same comments?
Well,
I mean, like, because we just already addressed
Mm.
those comments. So what if they're exactly the same comments?
Okay, so
Seeing
the APA steps the comment scope down.
Okay.
So the original scope was everything we're changing. Feel free to comment on it. The notice text is only the things we're changing. So you're only required to accept comments on comments that are related to the changes in the notice from the last notice. So just the things we covered, those 4 issues we covered about the renewal application, are we required to bring them back to you and discuss? Because they're required to only, they're directed in the notice actually,
Okay.
to only comment on the items that are being changed since the last notice was issued.
Mm-hmm. Okay, perfect. Thank you.
Mhm.
Okay.
So just while Christy's here, I'm just going to ask if none of the comments address the issue, the scope of what the public comment is,
Mhm.
and we do not have to accept them, and there are none that were accepted, do we need to have the board review?
No, so the motion says if the board receives no adverse comments related to the noticed modified text, right? So if they talk about things that were not modified, then we don't bring it back.
Mm-hmm.
That's by the delegation that lengthy, horrible thing, which nobody really listens to because it's terrible, and I get it. But essentially, it directs your executive director to only look at comments that come in that are related to the changes we've made since the last time. Just those changes. If they're not related to that, then we move forward with the rulemaking. And I'm hoping that we can do that. If we do get any adverse comments, we'll be bringing this back to the November board meeting, but I'm hoping we don't. If we do, then we'll be discussing the same way we did here, the comments and our recommendations at that point. If not, then we'll move forward through the internal review process and get filed hopefully with OAL this year. And then we'll just kind of wait and see what they think. And I'm hoping a good result will happen. If not, we'll bring it back to you again and make more changes. But just
Hopefully not.
persistence will out. I'll tell you that in my 26 years here, if you stay on target and you keep coming at an issue, you will get it addressed. So.
All right, thank you.
Okay, thank you. So the regulatory update, Agenda 15, is basically 2 packages. This one that we just approved for the modified text that will go out for public comment. And so hopefully that moves smoothly through the process and goes to OAL for approval. The second package we are working on is disciplinary guidelines, and we're still in the draft stages. The staff is working with Christy on the actual initial language for the disciplinary guidelines, and it is a very voluminous package because it is the entire disciplinary guidelines, and it's we're doing a very thorough job and adding a lot of information. And Erica, you could probably explain further.
Thank you, Terry. We actually have an image up on front. You can see how much we're meeting with Christy, and we've now taken on the role to do it weekly. We're meeting about 2 hours weekly with Ralph input as well to get through all of the language. I know that there's been a perceived believe that we're going to get this done hopefully by November and presented to the full board, and that's what we're shooting for. We do want to reiterate that we want to bring our proposals first to our enforcement committee. So Dr. Lockman and Mr. Cummins, you will be hearing from us soon, hopefully in the next couple of days or weeks, so that we can set up some meetings with you both to run our proposals by you before we bring it to full board. But Christy, thank you so much. It's been, it's actually very fun to go through the language. At least for me, for enforcement purposes, we're really putting a lot of effort into this. And as Ralph mentioned, it's going to be all full transparency as to what process we have for vetting our worksite monitors, our practice monitors, what documentation they're required to submit at what time. So there's not going to be any room for possibly questions in terms of what we're proposing. So very detailed document. We essentially are overhauling our previous, and that's what we're doing. We're repealing our last version to create a new one for you.
If you want to, this is Christy Shields again. If you want to get an idea of how old your current guidelines are, it still refers to triplicate forms. So, I mean, it's really out of date, 40 years, I think. So I think the goal once we get this to you is to, I would suggest hunting our strategic plan a 3 to 5 year consistent update to get that, you know, in a good way, keep it current. It won't be as much work, just like everything else, if you keep it updated.
That's it for this update, unless there's further questions.
Does the board have any questions for Terry? Any members of the public in the room? Moderator, is there anyone online that would like to make a comment on agenda item 15?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
All right, thank you. Moving to agenda
Thank
item
you.
number 16, a legislative update on pending 2026 legislation. Christy, thank you so much. Terry will continue.
Okay, thank you, Madam President. I'm getting a little tongue-tied here for some reason today. Okay, so I want to start by going over what do the things in the status represent, so they're not just a bunch of jumbled words to you and you understand what's going on. Briefly, I'm not going to go into a long summary, but briefly, a bill is introduced in January, and then it goes through policy committees. Which policy committees it goes through are assigned by what they call the Rules Committee in the legislature. Each house has Rules Committee. Each house has bill introduction. So if it's in the Assembly, it's an AB. If it's in the Senate, it's an SB. Okay, after it goes through the required assigned policy committees, it goes to appropriations. So in the Senate, Senate appropriations, Assembly appropriations, and that is the fiscal committee. But it also functions as the graveyard for unpopular bills, unpopular either that the leadership of each of the houses decides that they don't want this bill to go forward, or they don't like the bill or something. So one of the challenges is always, will a bill get out of the Appropriations Committee? And that consideration is fiscal in nature as opposed to the Policy Committee and the policy hearings that go after policy. If it gets through both houses and both appropriations committees, it goes onto the floor. And then it usually, if it's been amended, since it was in what they call the first house, they will require 2 floor votes so that everybody gets to vote on the current version of the bill. And if it is approved, it then goes to the governor. Okay, so if we look at the status, Senate appropriations suspense, Assembly B&P committee failed. So if you look at the status, if it failed to get out of a committee, as SB 1002 did, it's dead. It's not going forward. It has to get out of that committee, never reach the appropriations. If it's, for example, AB 2398, Assembly appropriations held under submission, that's also a sign that the leadership didn't want it to go forward, so it was held and it essentially will die. So all of the ones that we have, all the ones that have appropriation suspense, that's the part that when it goes on into the appropriations, it first goes what they call suspense. And then it has to proceed, get off of suspense. So that's 2 hearings, one to get on and in the committee and one to get off suspense to go to the floor for a floor vote. So because this was done 10 days in advance, things were still in at the beginning of August in the Appropriations Committee suspense file since they have moved. Okay, so basically everything that has a committee suspense has moved to the floor and moved out. So that's in our watched and our regular bills. And I will address, and then for the menopause is a trailer bill, which was something, it's bill language that explains the version of what's in the budget. So the budget is numbers, but it also has an accompanying bill, which they call a trailer bill, where they can add language that is supposed to be mitigating or explaining what's involved in the budget. So, and that goes into statute like any other bill, but it goes through the budget process, which is different. It doesn't go, I think it's heard once for budget hearings, but it's not going through policy. But policy can be included in it. So the trailer bill was a budget bill. And if you go to the end of the my memo on page 3, I have a little asterisk, budget trailer bill implementation timeline. There were many aspects of this budget trailer bill. The insurance mandates for Medi-Cal, insurance and Medi-Cal mandates will go into effect January 1, 2027. The mandatory screening and notification will go into effect January 1, 2027, and the provider continuing education won't go into effect until July 1, 2027. And just as a kind of a reminder of what was in that bill, it was originally based on a bill that failed. I think it got vetoed the first time around, and then it was modified by the governor, and he placed it in this budget. And among the changes was to change the CME from mandatory to permissive or discretionary. So they're not, physicians are not required to take CME related to menopause, but they are incentivized because unlike other CME, they are allowed 2 credits as opposed to 1 credit hour for each of the hours that they take. So that's sort of as best as it got in terms of people that were advocating for continuing education for menopause education. And then I just wanted to highlight AB 1703 at the very top, the title protection bill. That bill also got out of suspense and is on the floor, going through the floor process. That bill sailed through the legislature, both houses, with bipartisan support, over 2/3 support. And then at the very, very end, in the Senate Appropriations, there was a lot of opposition or some opposition that forced the committee, or the committee decided to make changes to the proposed language. And so those changes were made, and some of the bill was not changed in terms of language related to OMT, so that's good. A net gain in that perspective, but on the related to the title protection, that language was changed and modified. And I'll let Erica from an enforcement perspective explain what that does potentially for the board's enforcement.
Thank you, Terry. So first and foremost, I'd like to thank Holly and OPSC for sponsoring this bill. As you all know, this was a consumer protection on our radar type of bill. So we're very happy to see it moving along the way it has. One of the amendments that was done to specifically the title and what is of concern that we would like to bring to your attention today is that it fully doesn't protect the word osteopath. So the amendments that were made say specifically that individuals can still call themselves an osteopath, a so-called non-physician osteopath. They can continue to call themselves this as long as they don't advertise that they're doing so at the same time as perceiving that they are doing OMT or providing osteopathic services. So what does that mean for us? These individuals can remove their advertisement services online, and they can still call themselves osteopaths, leaving continued confusion for the public. If they see the word osteopath and they see it related to our physicians here in California, there could still be that confusion. So it doesn't completely title protect that specific word. It did add protection to doctor of osteopathy and DO, which is great. And then it protected OMT. Some of the opposition that came from that bill towards the end was also a belief that we were going to, I would say, criminalize action from physicians, physical therapists, acupuncturists, even massage therapists. So there was some amendments to clarify that nothing in this language pertains to those individuals that provide alternative healthcare options. So that was clarified. That was not ever the intention of this bill. And Holly, during public comment, you can add to that. It was more so to prevent OMT from being done by an unlicensed individual. The main concerns that we as staff had was that these are individuals that have not been fingerprinted and are providing these services either at their homes, in an unregulated setting, clinics that are not regulated by either Department of Public Health or the board. So that concern still stands. It protected the advertisement component, but it didn't fully protect the word. And then our concerns still exist that now with preventing certain or allowing the changes to happen advertisement wise, it would be harder for the board to even investigate these individuals. The only way that we can conduct investigations at this point is undercover operations, which are extremely costly for this board. Relying on consumers to bring forward these complaints to us. So it's something for us to consider. Do we feel like we're fully protected with what we were given from this outcome?
I would just add that for new members of the board, the context for why this bill was brought was because we had people from foreign countries that got some kind of a certificate that says they're an osteopath, come to California and they want to, open a shop and then say, hey, I'm an osteopath. Okay. But the key difference from a public safety perspective is no other program except the U.S. program is extensive in the training to include allopathic medicine in addition to osteopathic medicine. And that's a huge caveat in terms of why we need to have osteopath as a title protected. So nobody uses that because that's an alternative title still used by the AOA in their policy. And it's something that misleads consumers to think that they are fully trained. But the variation and the reality of foreign training, including Canada, is that there just isn't even standardization in the training for that certificate for just the osteopathic part of it. Not even the allopathic, but just the osteopathic part, no standardization. And then if they're not licensed, that means they're unregulated by the board. So there's no CME requirement. Our only jurisdiction is if we go after them as unlicensed individuals because they're practicing as unlicensed individuals. They can practice alternative and integrative medicine under a statute, but they have to fully disclose per the wording of that statute that they're not licensed and that they are offering these services as an unlicensed individual. And so it wasn't, the outcome wasn't as good. And I think that there was obviously more persuasion at the end about the worry about, what would be the consequences. But these individuals have been basically practicing not in compliant with law. And this bill was to try to clarify for our enforcement purposes and consumers what is an osteopath. And it's one that's licensed as a physician and surgeon.
I think it's also worthy of noting that our Osteopathic Act allows for these individuals to do it under the direct supervision of a osteopathic physician. So doing OMT in an office setting, clinic setting with the direct supervision of a doctor of osteopathic, it's allowed as an aid. There is the provision to allow 2 aides per physician. What we're hearing is that they're practicing alone without oversight in their own facilities.
Terry, may I ask what?
Yes.
Opposition, you said there was some convincing language in the opposition consequences. What would be the consequences other than protecting the public? Someone who shouldn't be doing that is going to lose their job?
Well, the consequence is there was a fine. They would be fined if they were found to be practicing in a violation of the Osteopathic Act. And so they were afraid of the fine is what basically they were feeling like they did exaggerate in terms of that they felt like they were criminals, but there is a fine in the section that we clarified who can use the title, which has to be licensed. And I think there was it happened at the very end in the last committee, there was traction about just the worry that, and there were 2 things. One, they extended the implementation date by a year as a courtesy to non-compliant people to get their act together for a year, so over a year. And 2, they were saying that they needed to, soften the language for them. And so the committee did this to soften the language. I don't know if it's like splitting the baby kind of thing or what, but it doesn't, I can't really explain the legislature's intent other than I think they were trying to satisfy the complaints, and those complaints were coming from unlicensed, foreign-trained osteopaths.
The main concern was that the board would go criminal, would pursue filing with the DA's office, and then they would be charged criminally for doing what they believe is assisting patients in California. So that was the main concern that we heard, was that they didn't want to be criminalized here in California, when their belief is that they're helping our community and providing services that they feel are in line with our profession. And this was their beliefs. So with that said, this board did expand our citation authority, and that is public knowledge. We can usually start with a citation for advertising themselves, as if this would have been completely protected. In terms of the title, we could start with educating first, going that route of helping them come into compliance and letting them know what the law requires and letting them know what they're able to do and not able to do. Move up the chain of a citation if they don't listen, in terms of taking down advertisement, to potentially, if there's harm that's caused to a patient, that we take criminal action. So that was the main concern that we heard. The other was that the board is or legislation is pursuing action that would then jeopardize their well-being. They have their businesses that they did not want to lose.
Just to add, Dr. Lockman, when you were saying specifically what's the consequence, with unlicensed practice, there's sort of two routes. All unlicensed practice should go through the DAs because it's criminal. By definition, unlicensed practice is criminal. The section in our act that we can enforce that had the fine, that is something that we, the board, can enforce. And usually we wait for the DA to take action. But the board in these unlicensed situations has its own authority to pursue the enforcement action against these unlicensed individuals, and it does come with a fine. So this was our authority in our act that we would use, that got modified about defining what they can do with respect to the title. So that's kind of the nuance difference. If the DA chooses not to pursue it, then the entire enforcement is based on our statutory authority to go after them in violating both the statutes as well as our act, which is where this was at. Our act has the title and the titles. So I know it's a little bit of a nuance, but for us, it was to be just like nobody else but a licensed physician and surgeon can use osteopath, was our clean way to be absolutely have clear authority. And I think in this new language, we have partial authority, just not 100%. And from, enforcement perspective and public safety, it would be good to have 100% authority to say that they're in violation of the use of, by representing osteopath. And to consumers, from a public safety perspective, the real harm is that in the advertisement, the consumer legitimately says, oh, I'm going to an osteopath. Oh, they must have been trained, correctly. There's no indication that they have less training than licensed physicians and surgeons. And the evolution of DOs has been that originally they used the title osteopath. And through the evolution of trying to integrate with MDs and residency got integrated, DOs use both DO and physician and surgeon, and they don't necessarily keep using osteopath, but according to the AOA, it is still a policy that is a title. And so it shouldn't be used by an unlicensed individual. The AOA policy specifically cites that they have to be licensed. And so that was what we were trying to absolutely 100% protect in the word osteopath. Does that answer your question about, so what are the consequences?
Sort of.
Sort of, okay.
So it's in the Senate Appropriations Committee suspense status. Next
And so now it's going to the floor. And so with the committee amendments, they will, and it was amendments by the committee and staff as opposed to the sponsors. Because up until now, the sponsors, OPSC was control of this bill, and they were the ones that dictated the statutes and worked with the authors. So when the committee, which was the Appropriations Committee, made those changes and amendments, they did that unilaterally. They have the authority to do it, and they just did it. And we didn't find out till
What
after.
are those?
What they were talking about, Erica, do you have the amendments close?
Yeah, so
If you looked at 1703, click on.
So it protected, so it says here, no one can call themselves a doctor of osteopathy or DO. So those were the two that were specific to title protection. So doctor of osteopathy was added and DO. The word osteopath can still be continued to be used as long as there is no indication that they are providing OMT services or acting as a physician, but they can still advertise as an osteopath. I mean, what we're seeing that's happening is there's usage of non-physician osteopath.
So in adding wording that says in a way that implies, that's the squishy wording. Like we just said that the osteopath as well as DO as well as physician and surgeon were not allowable for titles if you weren't licensed. So now if you add extra wording like in a way that implies, that is somewhat helpful, but somewhat not helpful, and basically dilutes the absolute prohibition of anybody unlicensed using that title. So that's the wording that they added to, I don't know, soften.
Yeah, this is like the most obtuse end run around the intent.
Yes, you are correct. I agree with you. It was kind of a shocking surprise to us. So, any other questions? And it was shocking since we did such a good job lobbying about this bill.
Well, sure, that begs the question, is there a large constituent of fake doctors out there lobbying to get their fakery codified?
Well, maybe 40 or more. And that's not large compared to the thousands that are licensed, but it's enough. And one of the things that it was surprising, to be honest with you, that this happened to us. But sometimes the legislature is more sympathetic to advocates and to these particular business people, if you will, even though they're non-compliant and potentially a risk to public safety, then and we're considered just government, so we're not considered maybe a white hat in the legislature in terms of a good cause. We're just the government. And so I think there was hidden sympathy somewhere in somebody in a position of power pulled these levers, and they could.
I think it's worth looking at the vote list on the ayes and to know who's in your camp and not.
So let's see here. Look at the vote when we go on to that.
It's everybody.
Huh? Yeah.
So a couple of things. Terry, thank you. That was a lot of information to take in. This is something that as a board we can discuss. Is this an avenue of us taking this up in sunset as a potential issue, right? With keeping in mind that our goal is consumer protection. Does this really, the changes, I mean, they're great in terms of if someone is doing OMT, they can't do it if they call themselves a doctor of osteopathy. But again, there is no clear knowing whether our consumers will understand that they're not physicians, and if they can still advertise somehow, the word exists still, that they're out there, that they're available to provide a service. And then the harm, that's the main gist is, for us, one of the questions that was raised is, are we seeing patient harm? Well, one of the things is, educational wise, we're still trying to teach our community that we even exist for them to come forward on a physician complaint, let alone an unlicensed individual. So does our consumer population know how to look up these individuals to see if they hold a license? The answer is no. We're barely teaching our consumers how to look up our own doctors. So those are all questions, concerns, mainly also just, I don't want to say what kind of criminal action we could potentially see if we, fingerprinted. We see that now, that there's convictions, there's concerns, but it could be up to the standard of, or up to the realm of, even sexual misconduct scenarios. Or, are the individuals, registered as sex offenders? We don't know that. And without regulation, without oversight, we won't know. And so I raised the concern that maybe we should, look into this for sunset.
Mhm. Okay.
Any other questions? Public comment?
Oh, you're done with the?
Yes, I'm
Okay,
done
Okay.
with my portion of it.
Okay.
I'm here to answer questions.
All right. Do we have any other comments, questions from the board? Okay. Yes, Holly, please come forward.
Holly McChris, OPSC Executive Director. Dr. Lockman, seeing how I was the one that was getting all of the letters of opposition, which there were many, they weren't just all from osteopaths. They were also from licensed practitioners, manual therapy practitioners who were being misled in what the bill actually contained. These were people who thought that their license or that their form of practice was going to be challenged. And we were able to let them know, working through their national, or some of the national associations and their state associations, to let them know that that wasn't the case. So we're hoping that those individuals now understand that physical therapists, chiropractors, certified massage therapists. We worked, some of the language that was amended was to help that group of people know that they're not also being targeted. So yes, the bill was about solidifying the OMT, which is already legislated as to be performed by osteopathic physicians and surgeons, that practice of medicine that you learned in school was protected for you to be able to provide. We had customers, patients, I'll call them patients, of people, not just of not a lot of osteopaths, to be honest with you. It was mostly of those who were from physical therapy, chiropractor, the licensed individuals who this bill has nothing to do with and will not touch their form of scope. As long as they stay in their scope, they're fine, right? As long as you're practicing within your scope. So what I want to tell you right now, so the bill did pass unanimously through every house, every committee and assembly, and every committee through the Senate, and it passed today unanimously on the Senate floor. So we have passed through the Senate. Now we move back to the assembly for the amendments that have occurred so that the assembly can do its thing, and we're hearing that it'll pass through the assembly and then move on to the governor. So the year pause really was from the assembly and Senate, who care and are compassionate about giving them an opportunity to figure out what they're going to do. They don't have a lobbyist, but they did form as an advocacy group, right? There are 40 of them, and they're trying to figure out what their next step is going to be. Yes, they can be an osteopathic aide and perform what they were taught as a certification in another country. We say they're internationally trained, but these are also American U.S. citizens who went and got an international certificate and brought back to the United States to practice this form of whatever it is that they thought they could do here, right? So that's another step that we have to figure out why they thought they could do that. But there are people who are osteopathic aides and they're doing it correctly. There are osteopaths that are working under osteopathic physicians and practicing it correctly. So again, those aren't the people that we're fighting or going after as well. It's the unlicensed part that's really very important to us. And the form that they use, DO, as part of their title, right? Because osteopaths who get
15
their
seconds.
sorry. So the DO thing, we will want to bring up in the sunset so that maybe that's another form where we can protect it. But know now that the bill passed through the Senate and is moving its way back to the Assembly.
Thank you. Moderator, do we have any comments from members of the public online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, so we are moving on. Thank you, Terry, so much.
Thank you.
Appreciate it. We'll start this journey again in a few months. We are now moving to agenda item 17, discussion and possible action to adopt the board's revised Osteopathic Medical Board of California Administrative Manual. And Erica will go over this manual with us and ask for any revisions to each page. Really?
I'm not. I figured what we're gonna do is just open it up for discussion. Just so we all understand what our manual is, this manual was last revised about 4 to 5 years ago under the prior leadership with the board. The reason why we're bringing it forward is in preparation for sunset. It is one of the attachments that we have to include with our sunset report. I will not go into each page, but just explain overall that the board's administrative manual is to provide the board members of the Osteopathic Medical Board as a ready reference for important laws, regulations, DCA policies, and board policies to guide the actions of board members to ensure that we have effectiveness within our board and efficiency. Keyword efficiency, so that we did not have to bring this document forward every time we change a process within DCA. The big overhaul of this packet was to do hyperlinks for a lot of the items to avoid the continuous of bringing it forward and having it adopted for you also as changes in laws, statutes, our travel guide for board members, our per diem changes, so will the hyperlinks that are attached to the document. So I think what we want to do at this moment is open it up for board members. If there's any edits that you would like to see in the different sections, today would be the time to bring that forward. If no edits, we will make a motion to adopt the document and allow me to work with our publications office to make it look pretty and user-friendlier with their edits. And I think we can just turn it to comments. Ms. Pines.
Okay. Do we have any board members who've reviewed the manual and have any comments or questions or potential additions that maybe they thought were missing from the manual? Mr. Cummings?
Yes, I had 2 comments, minor. On page 9, at the bottom of the page, there's a reference to 7 members being appointed by the governor and subject to Senate confirmation. Is that right? I don't think there's Senate confirmation of government appointees, right?
So we'll definitely fix that. There's a 9-member board, so we have to correct that. And we do have government appointed Senate, Machiko, Senate, and committee, right?
Senate
Yeah, the
Assembly and
nine-member board, I skipped over that. It actually does say the board consists of 9 members. But the thing that caught my eye was a Senate confirmation, because I don't think there is. So,
So we have
yeah,
the assembly, and, pro temp. Um, yeah, there's no. Your government appointed, not Senate confirmed, correct? Yeah. So we'll fix
uh,
that, John.
okay, yeah, it's minor. I just, it
Thank
stood
you.
out. I like this document. It's very helpful. And then the other thing is really minor, but when we quote on page 25, we quote the government code section 11430.10. And in the first sentence, there's just a minor typographical error. And since we're doing this, we might as well correct it. We say, while the proceeding is pending, there shall be not communication, there should be no communication.
Thank you.
Just, I hate typos in code sections. So that's all. I really think this is helpful. So thank you.
Do we have any other board members with comments, additions? Okay, moving to members of the public in the room. Okay, moderator, are there any?
Since I have a comment, since this is so vital to our board, I'd appreciate a little bit more time to overlook the manual for comments next time.
So, Nagin, and just to keep in mind, the reason why it was brought forward today was because we do need to bring our full packet at our November board meeting. I'm, we were hoping to adopt it today with edits moving forward. I believe we sent this out about a month and a half ago for the board to review. Happy to, Ms. Pines, if we want additional time, you guys want?
I think I would really appreciate that.
Why don't we give, another 2 weeks?
So with giving 2 weeks, we would have to bring it forward in November to fully adopt as part of the entire packet.
Okay.
So if we don't make a motion to adopt it now and allow us to work with publications, we would have to bring both items, this and our sunset. I was trying to help move along some of the review process because our sunset packet's going to be tremendously huge as well.
Okay,
So
another 2 weeks for board members who were not able to review during the time in which we sent it out, then that would have given 2 months to review this document. So another 2 weeks. Any other board members who want to review and make comments? And I know Dr. Walsh, you're just now actually getting a chance to review this as well for yourself. So does that sound like that's a fair enough time for yourself? Okay.
May I ask Yuping a question? Yuping, can we adopt this through our executive committee with proposed changes from the 2 members, or would we have to bring the whole packet back to the board? Could we take a motion to consider, we would have to bring it back to the entire board, or can we do it through the executive committee? Okay, okay. So we would have to bring it back to the table
Okay.
at our November meeting.
Okay. So all board members have a chance to review this between now and the next board meeting in November. Please do so. And I'm not sure if there's going to be anything else that's going to be very comprehensive that we would need to get to the board, considering the comment that was made, get to the board in enough time for review. Typically, most of the documentation that we receive should be 2 weeks before we have a board meeting. Anything that is very detail-oriented, such as a manual like this, we should be receiving that at least, I'd say 30 days prior, to take in all of our busy schedules.
Okay, so we're not going to take a motion today. We're just going to go ahead and work with the other members that might have comments. And then we will bring it back to the board in November with our full sunset.
Okay, perfect.
Right.
Do we have any? Yes?
Just another typo I just saw on page 3 as a, might as well correct it now or make note of it now. That central column, surgeon is misspelled. Second to last word, surgeon license, physician and surgeon license. It's surgeon.
And I just want to double check. We are, when we're talking about these comments of revision, are we all looking at the same manual? Because there was a revised manual that was distributed just on the 14th, 11 days ago.
I believe that's the same one. Yeah.
Okay, thank you.
Also, the first page says revised as of today's date, so that'll necessarily need to change.
Okay. Any other comments by board members on this manual? Okay. Did I go to the online people? I know I went to the in-room. No. Online, I think, yeah, yes. So moderator, is there anyone online that would like to make a comment on the manual?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, great. The manual is important, so I want to make sure that everyone has enough time to feel like they've reviewed it and can provide any input. So we are now at agenda item 18, future agenda items. I have an agenda item that I would like to add as a future agenda item, which is to direct the staff to analyze the associated costs for the compact, review Oregon's concerns, and determine which may potentially be applicable to our board of concern, develop a proposed timeline. So, and what I mean by the proposed timeline, if this were to be adopted in both of our sunsets, so our, OSTI board, Med board, what would be the timeline then that we would need to work from that point forward? Um, and to place this as an agenda item for discussion at our November board meeting. Are there any other board members that would like to add?
Can I add to that? Since NBC has already preceded us on some work and had a couple of meetings on this, can we also have that explicitly considered? Just so, just kind of like if they've already identified some issues that would, they may or may not agree, but
Mhm.
yeah, so not just the Oregon, but the California NBC, what their deliberations were on this.
Okay. Yep.
Just so I understand your request, Dr. Swain, you want to know what their concerns were for the last 2 meetings that they've had and provide that information at our next board meeting. And
I
then,
believe they're in favor of it, but I just want to make sure if there was anything raised that has not been, or that we might also feel strongly about.
okay, so my understanding from where I ended conversation with the medical board is they do have some additional concerns after their last 2 meetings. We do plan, Terry and I, to meet with medical board soon in the next couple of days for a couple of things, to ask questions regarding their sunset proposals, and then also in terms of the compact to find out what additional questions they might have. I think some of those questions could have been covered with the questions that I brought forward today. but we'll work with them to get more information. We can certainly have them come back at our November meeting. I do want to caution that in November, the goal is to have the board sunset report drafted with our issues already identified and what we're taking on, which includes if we're moving forward with the idea of the compact, it needs to be included at November. So if we need to schedule more meetings before that to have all of your questions answered, we can do so if you're open board to have that.
I'm actually just for transparency, I'm actually very enthusiastic about the idea of this. I don't think the concerns that I've heard today are actually what's happening. I think they're just fears that people have. But I'm also don't want to feel like we're rushing. So if we had to put this in a January meeting or something like that, I would rather do that than feel like we have too much to do in November to do it right.
Yeah. One of the questions that I have for the medical board is to see if they are truly bringing this up during their sunset. It could be, that they are, considering it, but we don't know yet. So that would be one of the questions that I do tend to ask is, are you including this as part? Because I've heard two different versions of that.
Do we have any?
And this is John Cummins. I do have some questions too. I was thinking of writing them up and as part of a possible submission to the commission compact, but maybe they're better considered if we have a group that's going to be working on this. I'm not really sure what the best forum is, but I have some concerns, and I'm writing up some questions.
So why don't we have our next meeting in November with and John, feel free to send your questions to Ms. Calderon. And then perhaps what we could do is put forth a task force committee to focus on this and get much more granular because we've had numerous conversation about compact. This isn't the first conversation. Like since I've been on this board, this is at least the fourth conversation. So this isn't new. Obviously, I've been on medical board. I've heard, this since 2017. So this isn't sort of new presentation, but this is probably one of the first times we are highly considering it. That's the difference. So not that this is new, not that the issues, even Oregon, any of that, these have been discussions with these two particular states for a very, very long time. So definitely
Yeah,
send
it's probably new for some of us. Though.
Yeah, no,
For some of
yeah,
us, I
I'm
think
just sort
it's
of saying
probably
in the
new.
ether of like, I just want you to know, like from board standpoint, this isn't sort of new considerations for us, but yes, for board members, I totally agree with you. So
Can I just
yes,
add context? Is that this is not just a board decision.
yes,
The legislature
Absolutely.
also has to weigh in with specific statutes to authorize. There's a lot of moving pieces for authorization. And so I think it would be wise to not rush something as complex as this so we don't end up with something that, we rushed past and thought like this isn't what we thought it was, and we didn't know that we would be controlled. So I think allowing maybe even a legislative season of discussion with policy committees and back and forth would be wise, even if the board, I think it would be rushed to have the board say, oh yeah, and take a vote like this is how many, support it versus not. I mean, it's complex and there are some consequences that are very negative that I think need to be aired out in this process. And the best way, I think, is public discourse through the legislature and the process. I know the legislature is interested in this, so another thing could be that they'd bring it up themselves, so we could be surprised. But the oversight process is not as much of a discourse as bills are. You know, bills are introduced, they go through both houses, they go through policy committees. In this case, I don't know if there'd be more committees assigned to it, you know, to look at all the moving pieces and the laws, particularly the idea that some of California or California law, the compact would supersede California law, huge. So on the one hand, it pits convenience against basically superseding all of California's laws that regulate public safety. That's a huge component that I think needs to have full airing.
So let me add something to that as well. If we could get for all the board members, like what the criteria of a physician becoming part of the PAC. Because I think if you understand how rigid it is to even be able to apply to become the PAC, I think that helps us understand as well. And I'm really referencing the comments that I heard from the public because we don't have the PAC here. A lot of us are not aware of sort of the criteria and the detail and a lot of the amendments that have been also made since 2017 when the PAC first began. And the first state was part of it. So if perhaps we could have that as well. And if we can somewhat get maybe that information early, I know it's going to take you a little time to put together the request that I've made, but that information, we should be able to, we already were sent the Oregon concerns, so everyone has that to start to look at. We'll meet with Med Board and also see what some of their concerns are and get to everybody from that point.
Yeah, I think that would be good. And just to give you a perspective, there's the eligibility upfront, and then there's the after it's implemented. One of the presenters made the comment that other states don't like to be told what to change. And so when you have all 50 states, one of which, like California, the 5th largest economy in the world, pitted with states that don't even have a board, I mean, that's apples and oranges. And so, you know, when California may be in a position to want certain things changed, okay, and all the other states don't. And so that's like kind of an after it's implemented concern of how it really will operate. That's why I think it's kind of complex.
Does anyone recall the attorney's name who was here in the co-presentation today? I heard it, but I didn't remember it. He wrote a book. And I don't know much about
right, he did.
compacts other than it's interesting that they fall into this very nebulous category where they're not state controlled. They're not really federally controlled. They're not a nonprofit with a board of board members. They're not a for-profit. So it's sort of this nebulous thing where everyone has this kumbaya hand-holding moment of consensus opinion, but who's governing them? And what if something goes awry and you want to implement some enforcement against the compact? Who's that authority?
It's a many-step process to make changes and make proposals. And it's not fast. So if the problem arises, it's not going to be solved immediately. And with federal, this compact superseding California laws, that can be very, very, very complex and kind of limiting in it. So that's buyers beware kind of approach. It needs to be weighed. I don't remember his name.
His name is Rick Masters.
Okay, are there
One last comment on that, on this agenda item or the topic, Ms. Pines. I do want to say that the medical board, when they first met, The board president at the time, Christina Lawson, did recommend that we put a committee together between both boards to address this. So that's another thing that I'm going to follow up is, are we ready to put together this committee? The suggestion was a member of both boards coming together to research, answer questions, and get all that information ready. Again, we need to find out if they're proposing to move forward. I think we have a very, very short window between now and our sunset. So if, like Terry mentioned, it could be very well worth just doing the research for an entire, year and getting everything disclosed. So we'll find out where they are at and hopefully get that committee going.
Okay, great. Any other comments or future agenda items that anyone wants to put forth? Okay. Any comments in the room? Moderator, are there any final comments online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, thank you, moderator. We appreciate your time today. And we are now at agenda item number 19. We are adjourned. Thank you.
November, you're going to decide January's, February's meetings. Okay.